So create a user increment, it's created. They say make sure the sound is correct. Then we'll do the editing part. Create it. You then go live. Can you see that one? Okay, perfect. Breaks like this. Okay, and then can you then let's can we share that link on Facebook, please? Please, let's do it immediately. Yeah. Make changes so that open to the presentation so that we know what it is. Show the presentation. She's reading. We're almost there. We put now in design and not slide. As we see it now, you will see a block at the bottom of the keyboard. The camera. Great. Yeah, maybe design and put yes. Alrighty. Okay. Okay. Can you open the chat of that one? In the meantime, can you open that for the delay? We will start shortly at 10:40. You can. All right. All right. Okay. Let's go back to the break slide. Yes. So,
Thank you very much. Colleagues online, can we get a thumbs up that you are able to hear us? We are back online. We do apologize profusely for the technical glitch. If you've just joined us online, welcome. If you returning after the technical glitch, welcome back. We had a presenter from WMN, the CEO of WMN, Ms. Zamango. I'd like to come back on stage again. As I indicated earlier on, please take this time while she's presenting to just bombard us with questions, comments as she's going through. We will then consolidate them and then would have an opportunity to ask questions. Thank you, colleagues.
All right, welcome back, everyone. We were just talking about the different procurement strategies that you can use in construction. We spoke about traditional procurement and design and build. And then we've got your EPC and your EPCM. So with the EPC, as I've said, the contractor is responsible for the design, the procurement, the construction, and gives the employer a facility that is ready for operation at the turn of a key. So now with the EPC is a lump sum price. Okay. Okay. So I'm just going to quickly run through these slides for the people who've just joined us. We're going to take you through construction in a nutshell. We don't have a lot of time, so we're going to try to do it quickly with me speaking like a normal person. So pre-construction, we've got procurement. In construction, when we talk about procurement, you're referring to two different things. There's the procurement strategies that you would use to procure your construction contractor, and then you've got procurement regulations, which we'll discuss briefly. I will then take you through how all the CIDB approved standard form contracts and how you go about choosing which one is appropriate for your project. And then we'll go into project execution. This is where your construction contract becomes super important. So we're going to take you through all the different principles in construction law, how they apply in the different types of contracts, and whose responsibility it is to action that principle. And then Tamlin will take you through claims and disputes. And we've tried to do it in the stage of a project life cycle, as you can see there in the corner. So I spoke about the different role players in a construction project. First is the clients or the developer, the person for whom you are building, the person who wants something to be built. Under the standard form construction contract, he is referred to as the employer. We then have the employer's representative who administers the contract on behalf of the employer. We then have the contractor who, as the name suggests, does the construction, is the construction contractor, who can then appoint subcontractors. We've got professional consultants, and we've got the adjudicator and the arbitrator who then they resolve disputes. The first thing you're going to do is a feasibility study, which is used to determine whether or not the project is viable. And there are various topics you'll have to cover under the study: technical, economical, legal, operational, and scheduling. So technical, you're looking at the site and the environmental factors and other factors around the site. You're looking at economical, you're looking at whether the project is financially viable. Legal, you're looking at legal compliance. Is everything legally sound? Operational, you're looking at whether the facility, when completed, will be fit for its purpose, for its intended purpose. And then scheduling, how long is it going to take? What's the program looking like? You then have the design, where the architect and the professional team start bringing the structure of the building to life in accordance with the employer's requirements and the purpose that he is building for. Here, the professional team will generate architectural, structural, electrical, and mechanical drawings, which will be used by the construction contractor to then construct. Procurement is where the contractor submits pricing estimates and a work plan for how they're going to carry out the works, and then the employer uses this to determine the expertise of the contractor and the potential costs of the project. So we've spoken about traditional procurement, design and build, engineering, and EPCM. Here's the diagram depicting the traditional procurement. So you see the client concludes separate contracts with each role player. So the designer, the contractor, the QS and such. So here, as you can see, the employer has greater control over each of the people that he appoints, but then when there's an issue, all these people can complicate the disputes in terms of who's responsible ultimately. We spoke about the JBCC case, where the JBCC is the traditional procurement contract where you appoint the contractor to do construction only. But there's case law where a hotel, I believe it was built and it was not fit for purpose. And of course, the employer went to court and sued the contractor. The contractor said, you gave me the design, I didn't do the design, and I just built in accordance with it. But the court said, even if you did not provide the design as a construction contractor, you do have a responsibility to identify, at the very least, all the patent defects in the design that could affect the construction. So you just need to know that even if you're only the construction only contractor, you do need to review the design and make sure that it's fit for purpose. Design and build. This is depicting traditional procurement. That's design and build. So you can see the difference. Design and build. There's one source of responsibility. Then you get your EPC. Your EPC, the contractor is responsible for the design, the procurement, the construction, and they give the employer a facility that is ready for operation at the turn of a key. The pricing is lump sum, and included in that lump sum is a risk premium that the contractor will include for assuming all of these risks, because the contractor assumes all of the risks in the project. Then you get your EPCM, your engineering, procurement, and construction management. So as the name suggests, the contractor does the design, the procurement, and the management of the construction. So they don't do the construction. They help the employer procure the construction contractors. The employer then concludes separate construction contractors with each of the construction contracts with each of the contractors. And the EPCM contractor then manages those contractors for the employer. So when we're talking about public procurements, our first point of reference is the Constitution, Section 217 of the Constitution. It says, firstly, when we're talking about public procurement, we're talking about the state. When an organ of state in the national, provincial, or local sphere of government or any other institution identified in national legislation contracts for goods or services, it must do so in accordance with the system that is fair, equitable, transparent, competitive, and cost-effective. So the Constitution then says governments must then implement legislation to give effect to this right. So the Public Procurement Bill was signed into law in 2024, and it is intended to be a comprehensive piece of legislation that governs procurement in South Africa. These are the various items of legislation that affect construction procurement in South Africa. So I've mentioned the Constitution. You've got the Promotion of Access to Justice Act, and I'll touch on all of these at a later stage. You've got the Public Finance Management Act, the Local Governments Municipal Finance Management Act, the Preferential Procurement Policy Framework Act, BEE legislation, and then we've got this new Procurement Act, and we've got the Prevention and Combating of Corrupt Activities Act, as well as the CIDB Act. So as I said, the LLB, I was saying before we went on the break, that the LLB degree, it teaches you where to go look for information. You're not going to know the whole of the law after completing your LLB. So with this course as well, you're not going to know the whole of construction law after leaving this room in 3 hours, but you will know where to go and look. And so this is the legislation that will govern procurement. This is just a simplified step-by-step of the procurement process. It's defined as the act of sourcing, acquiring, and paying for goods and services required for the organization to achieve its objectives. So you identify the need for the product or services, you issue a request for proposal or a request for quotations. I'll go into the difference between those two shortly. You evaluate your potential suppliers, you negotiate your contractual terms and conditions, you create a purchase order, you receive and review the goods, reconcile and match the shipments, the invoices, and the purchase order. You then approve and you pay for the goods, and then you complete the activity, you close out the activity. So this is procurement in general, but you'll see construction procurement follows the same process. So here you've got the beginning of the procurement process is after you've identified the need for the procurement, you then issue RFQs or RFPs. So the RFQ, you're just requesting quotations from the contractor. You've got your scope of work and you need to obtain competitive pricing. And so this is just a simple procurement method for simple works where the employer knows what they're doing. Then you've got the RFP, where the employer has an issue and they need a contractor to solve it, but the contractor must submit proposals as to how they're going to go about solving the issue, as well as the costing. So it's not just quotations, it's actually, you're kind of helping with the scope of work here. So that's the RFP, and it helps the organization define its needs clearly by consulting with contractors who are experienced, and then solicits competitive and innovative proposals. And then you select the most suitable one based on both the cost and the value. So this is the tender process just in general. You've got your terms and conditions from the employer. You've got your terms and conditions that the employer wants to use. Remember you'll see how it all comes together. When we're talking about your different procurement strategies, there are standard form contracts that you can use in accordance with the procurement strategy you've chosen. So for example, if you are going for the JBCC, it means you've gone for the traditional procurement method. And when you're going out to tender, you have to attach or mention that this JBCC will apply to this contract. And if you've amended the JBCC, then those amendments must be included in your tender. And then the contractor evaluates the tender, submits whatever returnable documents are submitted, the tender is evaluated, and then the contract is concluded. So this is what the tender documents generally will look like. There's a tender notice, an invitation to tender. This kind of sets out the scope of work, what is required from the contractor, and it must have sufficient detail so as to enable the contractor to be able to price for its works. You then have the tender data, which states the applicable conditions of tender and associated specific data that you would want to apply, the rules that you are applying to your tender. There's the list of returnable documents. So you have a list there telling the contractor every document they need to submit in order for their tender to be assessed. And then the returnable schedules, where the contractor must submit specific information. You've got your form of offer and acceptance, which formalizes the process of offer and acceptance. This is very important because this offer and acceptance is how the contract comes into being, and we'll touch on that shortly. You've got your contract data, and we'll talk about that when we speak about the standard form contracts. But this is where it's a part of your construction contract, and it's where you include all your contract-specific information that you need in order to make the contract workable. You've got your pricing instructions, which provides criteria and assumptions that the contractor will use to price for the works. Your activity schedule or your bill of quantities, where it basically sets out the rates for the proposed activities or the items of work you will complete. And then you have a more detailed scope of work, which sets out pretty much everything that the contractor is required to do. You have your site information, which sets out what's happening on site so that the contractor has enough information to do an assessment. Usually you'll also have a site inspection as part of the tender process where you can actually go to the site and see for yourself, which is very useful. Okay, so formation of construction contracts. The first thing is that you have to have capacity to contract. Remember that when it's all nice and well when you're concluding the contract. When there's a dispute, the parties, in some instances, will look for any reason not to be bound by the contract, including saying that the contract is actually not even valid. And so they can go back to who signed the contract and pick on whether that person had authority. So you need to make sure that the person signing the contract and the person acting in terms of it has the authority. You have to have consensus. Of course, you have to have agreement as to what you're doing, what it's going to cost. Also, a point of contention down the line when there's problems on site. Parties will come back and say, well, that was actually not my understanding of the agreement. And I'll tell you how to go about resolving those kind of disputes as well. What's important to know is that there's no requirements that a construction contract needs to be signed. So if you're the party who's disputing whether a contract is valid, that's not a ground you can rely on because a construction contract comes into existence once the contractor's offer is accepted by the employer. So when the employer issues an RFP or an RFQ, that's not the offer, that's the tender. What the contractor responds with, that's the contractor's offer to the employer. And then the employer then accepts that offer. Upon acceptance, usually through a letter of acceptance, that's when the construction contract comes into being. There's no requirement that it needs to be signed. So just be aware of that. And so can you make this a little bit bigger? This table, I've gone through the procurement process in general. So this is a construction procurement process, and it kind of shows you all the items that you need to undertake as part of that process. Are you able to make the table bigger, Tamlin? Oh, okay. Can you make this table a little bit bigger so that I may read it? Okay, great, thank you. So, I might need glasses because. So the first step is establishing what you need to procure. Ooh. And then go down a little bit. I feel like it's my fault. I definitely probably should need glasses. No, that's not healthy. Don't click. I mustn't click this. Okay. Okay, so the first step is preparing the scope of work for the procurement. You have to establish what you're procuring, the requirements. So you prepare the scope of work and you estimate the financial value of the proposed procurement. Then you decide on a procurement strategy. So we've spoken about those procurement strategies and a procurement policy. So internally, how you, as the public organization, and a lot of private entities also have procurement policies. It's not just something that it's a requirement for government, but a lot of private entities also do it. So you would then have your procurement policy, which is supposed to comply with the legislation. You then solicit your tenders, which means preparing the documents, inviting contractors to submit, receiving and assessing the tenders, and then inviting offers from a shortlist. And then you evaluate the tender offers. So you determine whether the offers are complete, determine whether the offers are responsive or not. Remember, you've got your list of returnable documents. If you haven't returned those, then they're not even looking at your tender. What's happening? But guys, the slides are all over the place. Okay. What's the last thing? You notify the successful tenderer. So, and that's just your procurement, the stages that you would go through when you're constructing, when you're dealing with construction procurement. I think you can make the slides a little bit smaller again, normal sized. Normal sized slides, please. These. I just needed it big for that table. But anyway, as part of your pre-construction activities, you will then have to appoint your professional team. Remember that we said as part of the design phase, you have to prepare your mechanical and all those schematic drawings that will then be used by the construction contractors. So the project team assists with all of that, the designers. So the project team is the contract administrator, the superintendents, all the professional consultants that you would have on the team. The key activities here at pre-construction, you would have pre-construction meetings to determine what the roles and responsibilities are. You'd have a risk management plan, which has to be detailed in the contracts. So remember that this phase, pre-construction, is where you're kind of finalizing, dotting all your T's and crossing, right, dotting all your I's and crossing all your T's before you start construction. So you've got your pre-construction meetings, your risk management plan, a work breakdown structure is generated to prepare the baseline construction program. Contractor conducts site surveys and inspections to assess the site conditions. This would have also ordinarily been done during the tender stage. The BOQ is compiled. You estimate the cost for labor, material, equipment, and regulatory expenses. You finalize your safety plan, and you finalize your construction contracts and define the communication channels. So a lot of things required here. Now, we spoke about how to go about appointing, I said I was going to tell you how to go about appointing your designers and your professional team. And in South Africa, guys, can we make the slides, there you go. Thank you. So we've got various standard form construction contracts, standard form professional appointments in South Africa and internationally that we can use. So the first one I've spoken about here is the NEC professional services contracts. The NEC is, there's an NEC 3 and an NEC 4 that are in use right now. And it's a UK contract, and we'll go into detail about how it works. But what you need to know for right now is that they've got a standard form professional services contract. So you don't need to go back, if your construction contract is based on the NEC, you don't need to go back and draft a bespoke professional services contract. They have provided one for you, which works well together with the construction contract under the NEC, as well as FIDIC. FIDIC has the white book, which is a professional services agreement, and it's intended to be used together with the rest of the FIDIC contracts, which I'll go into detail about. You've got your CISA model professional services agreement, which is intended for less complicated, low value professional services. And then we've got PROCSA, which is the main one in South Africa, and it's used together with the JBCC most of the time. So PROCSA is an acronym for Professional Client Consultant Services Agreements. They've developed this agreement for the majority of the disciplines in the construction industry. So there's a PROCSA agreement that has its terms and conditions, and it has a scope of work. And there are different types of PROCSA agreements for the different types of professional appointments that you'd need to make under a construction contract. And there's the list. So you've got a specific PROCSA agreement for the architect, For the development manager, the principal agents, the quantity surveyor, the structural engineer, the civil engineer, the electrical engineer, the fire engineer, the landscape architect, the mechanical engineer, the wet services engineer, the construction health and safety person, as well as the interior architect. So it's really helpful because the contract has terms and conditions, which are the same under all the PROCSA agreements, but then it has a scope of work documents, which is specific to the type of appointment you're making. So if you're appointing an architect, then the scope of work would deal with issues, with items that the architect must complete. So it really simplifies your life a lot. So, as I said, the agreements are generic in nature. The terms and conditions under each of the PROCSA agreements are the same. The purpose of PROCSA was being to standardize procurement in relation to construction professionals, as well as integrate the collaboration between these people, as well as implement good practice in construction, in the delivery of the project. So the bodies that came together to draft the PROCSA agreement are the Africa Association of QSs, the Association of Construction Project Managers, the Association of South African QSs, the Consulting Engineers of South Africa, the South Africa Black Technical and Allied Careers Organization, the South African Institute of Architects, and the South African Property Owners Association. So it's a bunch of really experienced people who came into a room together and decided, when you're concluding a professional appointment, what is fair to include in the terms and conditions. So it really just helps with decreasing the time it takes to conclude a contract, because you've already got this agreement that is prepared by specialists who know what they're doing. So the advantages of using PROCSA is that the agreements are drafted with consensus amongst these industry specialists. So you're getting all the things that you need that should be in the agreement will be in it. As I said, the scope of work document is what I really like about PROCSA, because it separates the scope into the 6 stages of a project life cycle. We spoke about inception, design, execution, closeout, all of that. Each PROCSA agreement and the scope of work sets out for the architect, this is what the architect must do and during the design phase, and these are the deliverables he must give you at the end of it. This is what he must do at execution, and this is what he must give to you at the end of that phase. So it's really, really great. I feel like all of you just go back and pick up one PROCSA agreement and look at the scope of work, and you'll see how comprehensive it is, and then you can also add to it or amend it as you see appropriate. But it's really useful, and that's the main standard form contracts we use in South Africa, used together with the JBCC. So it's drafted for local and international use. You can use it for any project, really. As I said, the same terms and conditions are used in each of the PROCSA agreements. So if you know one PROCSA, you know them all. It's a matter of seeing which scope of work documents works for your project or for your appointment. It enables changes during long-term projects. So you are able to vary the scope of work. You are able to vary the terms and conditions as well. It makes provision for professional indemnity insurance, which is provided by the consultants. It allows for dispute resolution. So you've really got a comprehensive contract that gives you everything you need to do. So I would recommend that, we make use of these CIDB approved standard form contracts, as opposed to consistently drafting contracts from scratch, and I'll touch on to that later. So as I've said, there's the terms and conditions, and then there's the scope of services. The scope differs with each consultant that you're appointing. Terms and conditions, and then there's annexures. The annexure A is the project specifics, which is like the contract data. So this is where you put all the project and party specific information that you need to make the contract workable. You then have your scope of services. Each work stage sets out the services. So you've got the 6 stages under PROCSA of a construction life cycle. And under each stage, you've got the services that must be done and the deliverables that must be achieved. And then you can also add your project-specific annexures to the PROCSA agreement. So it really does cut down the amount of time that you have to prepare an agreement. And it has all the clauses that you need in it. So appointment, duration, client obligations, consultant obligations, limitation of liability, professional indemnity insurance, fees, third-party services, disbursements, payments, conflicts of interest, corruption, confidentiality. It's pretty comprehensive. So PROCSA editions, we had our first edition in May 2008, and it's been updated. So I think we were talking about to someone earlier on about how people are still using 2002 editions or earlier editions, and how to get people to use more updated versions. I really think people just don't know that the agreement has been updated. So with PROCSA, we've got a 2021 edition that is in use. It's been updated last in 2021. I understand that they are currently updating it as well. So as far as I know, that they have not published an edition after 2021. But it's important to keep track of these, just so that when you're going out to tender, you use the most recent version of the agreement, because they are updated by industry professionals in response to the problems in the markets with the edition before. So it's important that you pay attention to all of that. Okay, so the obligations of the parties under PROCSA, we'll start with the client's obligations. He must appoint a representative, and we spoke about clients' representatives earlier, how they administer the contracts for the employer. The client is also obliged to furnish the consultants with the requirements, instructions, and information and decisions related to the project in a timeliest manner. Obviously, he must pay the consultants' fees and disbursements. He must notify the consultants of the appointments of principal consultants, principal agents, and other consultants, so that they can make provision for the interfacing of their work, and make available to the consultants the equipment and facilities agreed upon. If you've agreed at the beginning of the project that the employer is going to provide certain things in order for the contractor to complete their obligations, then all of those things must be listed in the contract. And then you must pay the client, is the one that pays all the costs levied by local authorities. The consultant obviously must execute the works in accordance with the contract. He must act in good faith, so no shady behavior. He must cooperate, comply with, and adhere to all reasonable requests by the client, the principal consultant, and other consultants. He must disclose any conflicts of interest and exercise reasonable professional care and skill in the performance of his obligations. So this last bullet point is pretty important, because this is how you hold them liable if you're not happy with their services. If they have performed their services in what you believe to be a negligent manner, then you can sue them on the basis of a failure to exercise reasonable professional skill, care, and diligence in the performance of the obligations. So, as part of your pre-construction activities is also contract selection. So the construction contracts that are concluded following the procurement process will touch on things like roles and responsibilities of the parties, contract price and payment, time and deadlines, risk allocation, and dispute resolution. Now, let me just give you a brief history into standard form contracts, just so you understand why they are so important. They were first introduced in England in the 1870s by the Royal Institute of British Architects, together with the Builders Society and the Central Association of Master Builders in London. So as you can see, different industry bodies. RIBA represents architects, Builder Society and the Central Association of Master Builders represents contractors, and they came together and they determined what would be fair to put into a contract, into a construction contract, and they came up with this. And then in 1909, the employers were like, wait, we're not happy with what you're doing here. We'd also like to be involved. So then they involved the National Federation of Building Trade Employers to have their opinion, and they updated the version and came out with the 1909 conditions of contract, which also now consider the employer in all of this. A subsequent edition was published in 1931, and in South Africa, we had our first standard form contract in 1932, which was based on the 1931 RIBA edition, amended to suit local conditions in South Africa. And from all of this, in 1984, the JBCC was established as an organization, the Joint Building Contracts Committee. And their intention was, of course, to then create a standard form contract specifically for South African conditions. This then takes us into the difference between bespoke and standard form contracts. Bespoke contracts are contracts drafted from scratch. So they're not based on any standard form. They are specifically drafted and customized for this project. So you're literally taking a Microsoft Word version and starting from scratch to draft a contract. That's what we call a bespoke contract. What's important to know before you choose to use a bespoke contract is that CIDB standard form contracts are preferred by banks and lenders for privately funded projects, simply because everybody knows what's in them, because they are used so frequently in the markets. And what you also need to know is that the CIDB actually prescribes that you use their approved contracts when you're contracting with governments. So you can't you aren't at liberty to use your bespoke contracts whenever you want. You do have to consider the requirements of the CIDB, the status of the employer, and the requirements of the lenders. So standard form contracts, these are pre-printed contracts with, oh, Tamlin, we said we were going to bring our little contracts. I think we forgot. Have you got one? Perfect. Just to give you guys. So this is what they look like, right? And you don't write on this contract. You'll keep using it over and over again. These are the terms and conditions. And at the end of it, they've got information that you can slot in. This is your contract data. Ooh, sorry. Yeah. So this is your standard form engineering contract by the NEC. Thank you so much. Perfect. When I need to, I'll take, yeah. So pre-printed standard terms and conditions, and to make negotiations of contract easier. And these terms and conditions reflect what the industry has agreed upon. So, for example, in construction, normally before we got to standard form contracts, you wouldn't have a client representative. You'd have the contractor and the employer concluding a construction contract. Now, these industry bodies noted the fact that not all employers know what construction law is all about. So you need a client representative who will administer the contract for the employer. So the concept of a client rep was introduced through standard forms. In the JBCC, for example, you have your principal agent. I hate the way my voice sounds on recording. And then you also, usually in a construction project, you would build and then you get paid at the end. The industry bodies sat together and said, that's not fair for the contractors. We need to have interim payments so that you can get paid throughout the project and maintain yourself in a cash neutral position. So through the standard form contract, interim payments were introduced. We then have amicable settlements. Before, you just go to court if you're not happy with what's happening in the under the construction contract. So now you've got amicable settlements, which is where the parties come together and we're not fighting, we're just talking to try and see how we can resolve this issue between us. And then if we don't succeed, we go to adjudication. Adjudication is also a dispute resolution mechanism that is very specific to the construction industry. It's intended to be a very fast-paced dispute resolution mechanism, again, to maintain the contractor in a cash neutral position. The idea is that we quickly resolve the disputes. If the contractor must get paid, they get paid, we keep it moving. But Tamlin will go into detail about all of that. And extension of time provisions. If before we had standard forms, if the contractor at common law, if the contractor was late, we would say time is at large. If he hasn't achieved a milestone, time is at large, which means then he must complete within a reasonable period. And a reasonable period is determined with reference to the project as a whole. So it's a very airy-fairy concept. And so what they've done is introduce extension of time provisions, where if you feel like the project will be delayed, as the contractor, you're obliged to submit a claim notice and notify the employer and work through all of that and mitigate your losses. And then if you've complied with the provisions, you will get paid. Bespoke versus standard form. And these are the CIDB approved standard form contracts that we're going to go into detail about. So we've got FIDIC, which is the French acronym for International Federation of Consulting Engineers. You've got the NEC, which is the new engineering contract. You've got the NEC 3 and NEC 4, which are currently being used. We've got the JBCC, the GCC, and we've got PROCSA, which I've touched on. So now I'm just going to talk about the other four. The JBCC, as I've said, it was established in 1984 as an organization, and specific industry bodies form part of this, of the JBCC, the Master Builders South Africa, the Association of Construction Project Managers, CISA, SAPOA, and Association of South African QSs. So all of these people came together and said, what is fair to put into a construction contract in the South African context? And so they eventually published the JBCC in 1991, and they've had subsequent editions, the latest being a 2024 edition. So it's very important when you're looking at your tender document and you're responding to the tender to look at which edition of the JBCC they are using. The employer will tell you in the tender documents, refer to JBCC edition, maybe 2004. So you have to go and source that one and look at it and make sure that you are happy with it. If you're not happy with it, you are able to prepare a list of deviations and submit it as part of your tender and say, this is how these are the prices, this is our proposal, but we don't agree with these terms and conditions in your contract, and these are our proposed terms and conditions. And when the employer is assessing your tender, he'll consider that, and because the terms and conditions also play a role in risk allocation. So the employer will consider all your responses and determine on that basis. So just important to remember that you can amend what the employer has given you. So the JBCC, it's a suite of contracts. It's not just one contract. It's several contracts that are within this suite. The first one is the principal building agreement, the main construction contract, concluded between the contractor and the employer. And then you have the principal agent, who's appointed by the employer to administer the contract on behalf of the employer. You also then have the minor works agreements, which is a simplified version of the JBCC. If you're building something that is less technically complex, in a short period of time for a low amount of money, you probably want to look at the minor works agreements because it's less complex. You then have the nominated selected subcontractors agreements, which, as the name suggests, it's a subcontract agreement that you can use to appoint a subcontractor under the principal building agreement or the minor works agreement. You then have the small and simple works contract. This is intended for small and simple works, as the name suggests. Just low value works where I think the JBCC says that the building mustn't be more than 2 or 3 stories. That's when you kind of want to use this. So they do, an important thing to do is also just read at the beginning of these contracts, not the NEC, but the other ones, FIDIC and them. They kind of give you a little intro and they talk about, the contract. So that also gives you an idea of what you're dealing with. So it's just important. We find that contractors will come to us when there's a dispute and they have not even seen the contract. They don't actually know what an NEC contract looks like. So I'm going to just keep reiterating how important these are. And then you have the direct contractors contract. So this is where the employer wants to appoint a contractor in addition to the main contractor under the principal building agreements. So you'll have the main contractor under the PBA, but you want to maybe have someone come and install a surveillance system. Then you would appoint them in a separate contract under the direct contractors contract, so that the employer may have direct control over that contractor. So as I've said, this is a construction-only contract. So when you think about your traditional procurement methods, this is where the employer will conclude a contractor with a designer to do the design, and then they'll come in to include a JBCC principal building agreement with the contractor. So just remember that the contract is administered by the principal agents, and it's divided into 30 clauses with all the comprehensive things that the industry bodies thought need to go into a construction contract. So a very high-level summary of the JBCC. We've then got your GCC. I think the important thing to note is that JBCC is a South African contract, as I've said. GCC is also a South African contract. And so we're going to talk about the local and the international contracts. GCC, but I know that JBCC and GCC are also used in other African jurisdictions like Namibia and stuff. So the GCC was published by South African Institute of Civil Engineers, and the first edition was published in 1990, and the latest one was published just last year. So it's written in plain language. The idea is that these agreements are used by technical people, not lawyers for the most part. So they try to make it plain and just not too many of here with therefore words like that. Just keep it simple. And so that's what they've done here. And they've made it flexible so that you can use it as a design and build or traditional procurement. And you can use it with lump sum pricing or remeasurable pricing. And we'll go into the different pricing methodologies at a later stage. Then you've got FIDIC. This is one of the big contracts I'm sure you've come across. How many people have used the JBCC in the room, just by a show of hands? Okay. How many people have come across the GCC? Have anyone come across FIDIC? Okay. So I have no issues with FIDIC. It's a good contract. So they have their headquarters in Geneva, and South Africa is a member through CISA. In South Africa, the FIDIC was used for Medupi and Kusile, I'm sure you would know, and the renewable energy projects.
Sorry, Zama.
Yes.
Once you're still asking, can we get an indication also from our colleagues online of which contracts they've used or currently using?
Yes.
Yes.
If we can.
Yes, I know you've used those. I know you've asked for those 3. Perhaps you can also get an indication in the room as well, to find out which contracts are we currently using or used before. Contracts? JBCC. JBCC mostly. Okay, let's get an indication from our colleagues online as well.
Okay.
Thank you very much.
All right. So the nice thing about FIDIC is that if you use one FIDIC, they're all structured the same way, and I'll go into the different types of FIDIC agreements. And they also have guidance notes and a lot of things to help you maneuver the contract. So it's important, and they've got pro formas at the back of it. They've got a pro forma performance certificate, and all the documents that you need to use in the agreement are there at the back. So it's pretty comprehensive and pretty useful. And there are different types of construction contracts, construction type contracts within the FIDIC suite. So you've got your FIDIC Gold Book. Has anyone come across the FIDIC Gold Book, just by a show of hands? So this is design, build, operate. As the name suggests, the contractor does all of those things. They design, they build, and then they operate the project. You've got your EPC contract, which we spoke about, your design and build, which we spoke about, your construction-only contract. That's your red book under the FIDIC. And then the pink book is a red book, but where the project is funded by a development bank. So it just has specific provisions that the banks can relate to and will agree to. Remember, I said all the industry bodies sit together and determine what's going to work. And so the banks prefer standard form contracts because of this. So then you have the green contract, green FIDIC, which is a short form contract it's the equivalent of the JBCC minor works agreements. So for small, technically incomplex, low value, short duration type construction. You've got your FIDIC blue, which is the dredging and reclamation contract, and then your FIDIC white, which is the professional services contract, which we touched on earlier. I'm not going to go into all of them. I'm going to go into the ones that we'll come across most often in practice, which is the red book. When you determine that you're using the traditional procurement method, so you're concluding separate contracts with your designer and your construction contractor, you already have to, in your mind, limit yourself, because now you know that if I'm going to use FIDIC, then the red book is construction only. If I'm going to use JBCC, then that's a construction only agreement. The GCC is flexible, so you already know that if you're doing design and build, don't even look at JBCC. You kind of have to start thinking like that. So the employer provides the design, contractor builds in accordance with the design. What FIDIC has done is also published a subcontract for this. So if you're using FIDIC Red and you want to appoint a subcontractor, you don't need to go and draft a bespoke contract. FIDIC has prepared one for you that you can use and amend to your satisfaction. An important thing to remember when you're amending these contracts, remember you've got your standard form contracts, but if you're not happy with a certain term, you can negotiate that it be changed. But the CIDB says you mustn't now amend your contracts to the point where it becomes something other than what the drafters intended. So if you are using a FIDIC yellow book, and then you say, if you determine that you're going to do construction only, the traditional procurement method, and then but you're like, I like FIDIC yellow, so I'm actually just going to use FIDIC yellow and amend it to my liking. That's not, the CIDB says don't do that. Use the FIDIC red if that's what you're doing, because now you're amending the FIDIC yellow to become a FIDIC red, which is not what was intended. So it's not about what you like, it's what's in the best interest of the project. Which now we're touching on the yellow, the design and build contracts. So here, the contractor is, of course, doing all of the design and the construction. And the clauses are, the risk is apportioned in accordance with that. You've got your FIDIC Silver Book, which is your turnkey contract. The contractor must deliver a complete facility that is ready for operation at the turn of a key for a fixed price by a specific date, and it must achieve the guaranteed performance levels. So the contractor takes completion and performance risk for the entire project, which is why, as part of the lump sum pricing, the contractor will include a risk premium, just so that the employer is paying for them assuming all of this risk under the contract. Because, as we've said, they do everything and they provide a complete facility to the employer. Then you've got the NEC contract, and this is the NEC contract, just an older edition. So this was a UK contract published for the first time in 1993 by the Institute of Civil Engineers in the UK. In South Africa, we currently have the NEC4, NEC3, and NEC4 in circulation. NEC4 was published in 2017. This is the NEC3, 2023, it says here, 2013, sorry. But it was published before that, the first edition of the NEC 3. In South Africa, the NEC was used in specific projects. The construction of Wits University was done by using the NEC. And I don't know if you guys are aware of Eskom's Ngula Pumped Storage Scheme. That's a project that uses the NEC as well. So under the NEC, remember we said standard form contracts have a contract administrator which administers the contract for the employer. That person is the project manager under the NEC. Under the JBCC is the principal agent. Under FIDIC is the engineer. Under the JBCC is the employer's agent. Yeah. And so the NEC also has a whole suite of contracts. So you don't need to use the JBCC and the NEC in one project. If you choose NEC, you've got all the contracts that you could possibly need, and you're encouraged to stick to that suite. So the NEC has the construction contract, the subcontract, the short contract, and the short subcontract. So the ECC is the construction contract. There's then a short form contract of that for minor works. Then there's a subcontract, and then a short form subcontract for minor subcontract works. You then have, so that's your construction contract. You then have your professional services contracts, which I spoke about before I touched on PROCSA. You've got your term services contract, and this is for services which don't fall under the category of professional services. For example, if you're doing routine maintenance over a specific term, you'd conclude a term services contract to govern that, because it's not necessarily construction, it's not professional services, but it is construction related services. So that caters for that. And then of course you have suppliers who have to provide you with certain material and stuff. So you can conclude a supply contract for that. You don't need to go and prepare a bespoke contract or look too far elsewhere. When a dispute arises and you want to appoint an adjudicator, you also have an adjudicator's contract, which is then an agreement concluded between the employer, the contractor, and the adjudicator in order to resolve the dispute. So it's got, this is the structure of the NEC. It's got 9 general clauses. So these are called your core clauses, and they deal with normal things that you'd find in a construction contract, like the contractor's responsibilities, time, testing and defects, payments, compensation events, title, risk, insurance, and termination. So those are called your core clauses. And you are able to amend your core clauses by using what we call Z clause amendments. So and in a separate document, you will have a list of all the core clauses that you weren't happy with, and you will propose your amendments to those clauses. You can either propose that it be deleted or that it be amended, but you'd have to do so under the Z clause amendments. So that's the first part, your core clauses. The NEC contract is quite interesting because you kind of have to build your contract. You can't just take this and go to site. You have to interrogate this document and select certain things that will apply to your contract. So you've first got your core clauses. These apply to the whole contract, all of these core clauses, and you can amend them through the Z clauses or delete them through the Z clauses. Then that's the first step. Then you're building your contract. The second part of building your contract is choosing which pricing option will work for you. And the NEC has 6 different pricing options. So a priced contract, which is a lump sum contract with an activity schedule. An activity schedule is unlike the BOQ that has items of work and rates. This has the specific activity that you need to complete and then an amount attached to it. So it's really a breakdown of the specific work items that are in the scope with the price attached to it, so that you can kind of determine at the end of the activity what's been done and how much you're going to be paid for that. So you've got your option A, your activity schedule. You've got your option B, a lump sum contract with a bill of quantities. You've got a target contract. This is where your price is not set in stone, it's a target price. And then at the end of the construction period or the interim payment period, you assess the work that has actually been done and then you pay that. Cost reimbursable. So there's a target contract with an activity schedule and also one with the BOQ. So you will choose what works for you. And you obviously can only choose one pricing mechanism for your contract. And it's very important that you choose carefully in the beginning. We've had a dispute where halfway through the project they wanted to change their pricing mechanism, and it created a lot of issues. I'm not saying it's not possible, I'm just saying it's absolutely not recommended. So do apply yourself properly at the beginning of the contract so that you avoid all of these issues. As much as we are good at resolving disputes, that's not the point, right? The point is construction. So you're drafting a contract that seeks to minimize disputes or mitigate against them. So, and that's why the beginning is important. Yes. Yes, you can. It's fine. You can.
Okay, who is exactly choosing the type of contract to use? Is it the employer or
It's the employer. Remember, it's your project as the employer. You're the one who wants something to be built. So it's you. You're the one determining all of those things. Yeah. So you will determine where it's going to be, what contract will be used, what the procurement strategy will be, all of those things. Yes, Kathleen.
Can I ask that she repeats the question because I didn't get.
Oh, okay. I can repeat it.
Okay, you can repeat.
She said, no. Kathleen is my boss, so she says you must answer it. You must ask it again.
Okay. I wanted to ask, uh, when we are doing the project or when the client have appointed the contractor to do the project, who is exactly choose the type of contract to use? Is it the employer or the contractor?
Yes, it's the employer because remember you've got your project initiation, you've got your design phase. At that stage, you're determining your procurement policy. Before you've gone to procure your construction contractor, you're determining what's going to be a procurement policy. Am I going to do a design and build, or am I going to do a construction only? Is it going to be EPC or EPCM? So that's all before you've appointed your contractor. So it's the employer's job because it's the employer's project. They are the ones who know what they want and what the purpose of this is. You've got the cost reimbursable contracts where the contractor is reimbursed for the cost that they've spent, and then you've got your management contracts. So you have to pick one, and which one will work best for your project, and you pick it. That's part 2 of building your contract. And then you have to go to part 3, dispute resolution. The NEC has 2 different dispute resolution clauses, one used in South Africa, one used in the UK only, and the other used everywhere else in the world, including South Africa. But Tamlin is going to go into dispute resolution with you guys. Then you have to pick either W1 or W2. So you've got your core clauses, you've amended them as you see appropriate. Then you've built your contract by choosing a pricing option. Then you've built your contract some more by choosing a dispute resolution option. Now you're building a contract some more by determining which secondary option clauses you're going to use. These are the X clauses under the NEC. Now the NEC has a whole list of them. And these clauses are important for determining risk in a contract. So it's very important with the NEC, especially that you interrogate all of this at the beginning of the contract, so you understand what you're doing, so that you can select the options that are applicable to you, and that that will be in the best interest of your project. So the types of X clauses you'll see are price adjustment for inflation. So if you've got a long project, you want to select X1 because it will allow you to amend the price and adjust it for inflation. If there are changes in the law, X2 deals with changes in the law. So if you've got a long contract as well, and during the duration of the contract, there might be updates in the law, you want to select option X2 because it will allow you to do that. There's also X3, multiple currencies. If the contract price is payable in multiple currencies, maybe because there's an offshore element to the works, then you want to select option X3. There's also different types of, there's a whole list here. So bonus for early completion, you have to select a specific X clause. If you want delayed damages to apply, you have to select it. If you want the contractor to provide a performance bond, you have to specifically select it. So unlike the other contracts, JBCC and FIDIC, where you have to include the information in the contract data, here you actually have to, let the contractor know that these secondary option clauses will apply. And if you haven't done that, the contract becomes a little bit unworkable. Although as lawyers, we always find a way around it. But don't make our jobs harder. So there you go. Now you've got your complete contract with your core clauses that are amended through your additional conditions of contract, your Z clauses. You've got your main option clauses, your dispute resolution, and your secondary option clauses. So the thing about the NEC, it talks about in clause 10.1, it obliges the parties and the project manager and the supervisor to act in a spirit of mutual trust and cooperation. So all the role players in the contract have to exercise good faith towards each other. There has to be collaboration. You, as the parties to the contract, have to buy into the ethos of the NEC. You actually have to put your collaborative cap on, and you'll see how the contract really does work if you buy into it as a person, as a contracting party. So it requires proactive proactive contract management. For example, there's an early warning mechanism in the contract where if the contractor or the project manager become aware of anything that's happening on site that might increase the price or delay completion, then the contractor is obliged to issue an early warning notice to the employer and project manager saying, hey, listen, I think that there's going to be a strike on site. I hear a little bit of commotion. Then the parties have to come together in what is called a risk reduction meeting, and they have to come and find ways to mitigate against this risk. So that's a really nice concept that is in the NEC 3 and that is in the NEC. And sometimes when we're amending the FIDIC contract, we'll add that in because it is a nice contract management tool. So there's emphasis on communication in the NEC. One thing about the NEC, it's very admin intensive. It requires you to really thoroughly engage with the contract. And if you don't, you're gonna come into problems. And if you do, you might have a really smooth project. One of the things that they are very strict on is communication. At the beginning of the contract, when you're completing your contract data, the parties have to agree on a period for reply. So if there's a contractual communication that is given, you'll agree at the beginning of the contract, whether it's 24 hours, 48 hours, or a week that you have to reply. The importance of that is that if you get a contractual correspondence and you do not reply within the period for reply, the contractor can make a claim because now you're delaying them from getting information that will help them proceed with the project. So as the employer, you need to understand the NEC and also have the resources to deal with the NEC because there are so many provisions like this that can almost trip you up. You'll realize that, you didn't respond for the period of reply. Now you're liable for something, so you really do need to understand how the contract works and engage. It's flexible. As we've said, you're building your own contract, so you kind of can do it what you want with NEC, within the framework provided, of course, and you can amend it to the extent that you want, in line with the CIDB's recommendation that you don't change it to something that is completely different to what the draft is intended. So again, it's written in plain language so that it's easy for use with construction professionals. And then how to go about choosing an appropriate contract. So how are we for time? How much time do I have left? I'm just going to try to go quickly. Okay. So you've got your JBCC, you've got your GCC, you've got your NEC, you've got your FIDIC. Which contract should you use for your project? How do you go about deciding that? The first thing is the procurement strategy. So if you're doing construction only, you already know that you've got access to the JBCC. The GCC is flexible enough. The NEC is flexible enough. And FIDIC Red is the contract that you're going to use. If it's a design and build strategy that you're going for, then you already know that it's your FIDIC Yellow or your NEC and GCC are flexible enough to do so. The technical complexity of the pricing strategy. Pricing strategy is also important. Most of the contracts are flexible in that you can use whatever pricing strategy you choose with the contract. You saw with the NEC, you've got options. The GCC is also flexible. But with FIDIC, it becomes a little bit more of a red-yellow, depending on what you're choosing here. The status of the employer is also relevant, whether they're a public or private sector employer. The JBCC has a specific contract that can be used where the employer is the state, and it has specific provisions that apply to the employers, to public entities, taking into account procurement legislation that applies to them, so the PFMA and other legislation. You also need to make sure when you're selecting your contract that your internal procedures are compatible with the contract's procedures. I say, for example, the NEC is a very intense contract, documents heavy. You need to constantly be communicating and be collaborating. So you need to make sure that you have the resources to deal with that, and that whatever you've agreed in your contract is in line with what's happening within your organization. We often have to amend payment clauses, for example, where if the clause says payment within a month or whatever, if your payment terms are 45 days, then you have to amend the contract to specify that. So just make sure that whatever's in the contract is in line with your organization's policies. Because if it's not, then amend the contract so that you're not in breach of the contract as soon as you start. So yeah, we've discussed how the procurement strategy, it's determined at the early stages of the project. I'm basically going through this list again. But yeah, procurement strategy Here are the strategies that we spoke about. An important thing to know when you're determining which contract to use and allocation of risk in the contract is to consider the principles of risk allocation. So there are certain principles which are intended to guide us when we are kind of determining who does what and who's going to be responsible for what. So the first principle is that risk is allocated to the party who can best manage it as evaluated at bidding stage. So the contractor is on the ground and is able to see when there's going to be a delay on site, which is why the early warning mechanism places an obligation on the contractor to notify an early warning. The contractor also has to notify a claim on site within a certain period of time because you're on site and can see what's happening on site. So don't sit on your claim and wait. You have to notify it within 20 days or whatever the contracts say. So all of those things take into account these principles of risk allocation. The next principle is that risk allocated to the party best able to insure against it or transfer it through a contract. So, for example, if you are best placed to insure against damage to the works on site, then you will be the party who has that liability because it's easier for you to mitigate or avoid it or transfer the risk. Also, if you're subcontracting, there are certain risks as the contractor that you have to transfer to the subcontractor, and just bear that in mind. Risks are allocated to maximize project efficiency. As I said, it's not about what you like or prefer, it's about what's in the best interest of the project. If a risk arises out of a party's willful misconduct, negligence, or lack of care, then that person must be responsible. So you can't create a risk and then hand it over to someone else. If you created the risk willfully or negligently, you'll be responsible. And then in construction, one of the principles that are specific to construction, well, not really, is that specific clauses are used for risks that neither party can control. So, for example, a force majeure are dealt with separately from all the other delay events in construction contracts. So just consider that. Then you've got another factor that you would consider when you're determining which is the most appropriate contract to use are the pricing strategies. And I've gone through the different pricing methodologies under the NEC and how the other contracts are quite flexible. But it's something that you would be determining at the beginning of the project and drafting it into your contract. Other factors that will determine which of the construction contracts you're going to use for your project is the technical complexity of the project. We've spoken about how some of these contracts have minor works agreements, which are for more simple works and stuff like that, or you have the principal building agreements, which is the main contract. So you will choose the amount of involvement from the owner and compatibility, as we've said.
Sorry, Zama, I just want to find out in terms of the different types of contract, from the majority of the people in the room, they're currently using JBCC contract. Are you going to go into details in terms of JBCC contract as well?
Yeah, so I was going to, after this, go into the different principles that are relevant in construction, but maybe then I'll focus it on JBCC and not so much FIDIC. I'll touch on the others, but focus on JBCC.
Okay, thank you.
And then you have now selected your procurement strategy, you've selected your contract, and now you've issued your RFP or your RFQ, and you've selected your preferred bidder, and now you're negotiating the final contract. You must understand that a negotiation is not just a lawyer's job. It's a collaborative effort between legal, technical, and commercial, because I need to know what the commercial outcomes or the commercial goals are for the project so that I may incorporate that into the legal terms and conditions. I need to understand what the technical guys want out of this, what the technical guys are concerned about in relation to this, so that I may draft that into the contract. So it really is a collaboration between technical, commercial, and legal. You need to understand the project requirements, which you will get from the technical and the commercial teams, so that you may draft an honest, a proper contract. Be honest about risk. So sometimes you'll find lawyers who, when you're negotiating the contract, they slip in some amendments there without telling you, and it's like, what are you doing? Like, this is just gonna create a dispute later on. Can you just be honest about what we're doing and who's responsible for what, and just let's put it all out on the table in the beginning and be fair. So yeah, it's a collaborative process, not a combative process. You know how when people are getting married and then you suggest an antenuptial contract, and you're starting a fight now. It shouldn't be that way. Like, well,
Sorry, because I want to try and make it an interactive session. I want to find out at which point do contractors know what sort of steps to take to be able to come around the table and negotiate with the employer. Because oftentimes, what you find is that you have contractors, because they are on the receiving end and they don't know their rights, they don't know what sort of actions they can take to negotiate certain things, because at that point all they're excited about doing is getting the job and getting the job done. So I want you to give us practical examples of what it is that we should do as contractors to position ourselves to be able to be proactive in terms of even doing certain things when you receive. So I think even when you go into JBCC contract, which is what majority of people are using here, is when you receive the appointment letter from the client, what do we do?
even before
How
that.
do you, yes, even before that. But I want you to dive into practical examples. And also when you talk about dispute resolution, try and link it to cases that you as the lawyers have been able to deal with
Yeah.
in terms of resolving, and try and give us practical examples in terms of pitfalls to avoid in how, as contractors, we position ourselves and how we do these contracts in implementing projects. Thank you.
No, for definitely. So even before you get to the point where you're negotiating, I'll come to you after this. It starts with the tender, guys, and how you mitigate your risk is by reading thoroughly. Because all of this information is in your tender documents. They talk about which contract we'll be using. So we'll be using the NEC ECC to April 2013 edition. So now you know I have to go find this contract. Before I respond to my tender, I need to find this contract and see what it says, firstly. It's not just about the scope of work anymore, it's about the terms and conditions too. And once I found the contract to see what it says, I must thoroughly engage with it and read and see what I don't like about it, what is concerning to me about it. In the tender, if you read thoroughly, you'll see that there's a section that allows for you to submit a schedule of deviations. So what in this tender are you deviating from as the contractor? Yes, you want the works, but there are certain parts that you don't agree with as the contractor. So what are those? You need to stay, as part of your tender submission, you need to tell the employer that, so that they can assess your tender and look at the price, but also look at what you've deleted in the contract, because that affects the risk. And then they will decide who is preferred in light of even the changes they've made. Once you are preferred, then you have a point to start negotiating, because you told them at tender stage that you don't like these clauses. So they've appointed you knowing that we still have to talk about those clauses.
Thank you very much.
Yeah.
I love the example you've used. But we're sitting in a room where majority of our contractors are not even at the level that they could make that sort of decision to say, I don't like this. Okay, maybe not. It's the right wording would be they're not capacitated to be able to make that decision. So where is a somewhere where they could get help, assistance? Is there even at tender stage? Because majority of contractors that we're dealing with are sitting in a position where they're not technically inclined, they don't understand. So all they do is obtain, pricing from, if it's materials from the different suppliers, if it's the laborers from they obtain information somewhere. Is there a portal from a law side in terms of contracts where there could be some form of assistance in terms of getting this kind of information?
So The only place that you can go is the CIDB website. You know, the CIDB is doing the Lord's work. They put everything there on the website for you. And they also have classes like these where you can come and get some knowledge. Unfortunately, outside of that, you're going to have to consult a lawyer. But we also do want to see small contractors win. So we are able to negotiate rates specific for the small guys who are coming up. So there's really no way to avoid lawyers, guys. Sorry. You kind of really have to engage with us. And rather at the beginning, I mean, Tamlin and I constantly have problems with the smaller contractor where they come to you when the problem is just so wild, you know, we can have to kind of go to court to solve it or come out of the contract or something. Whereas if you had come to a lawyer at the beginning of the project and you had consulted thoroughly, even for a small fee, we you know, build a relationship, we make it work. But it saves you so much money, so much time, so much struggle, so much confusion down the line, just because you started off properly. So when you come halfway to the project, I once had a contractor, it was the most horrifying thing. A contractor come and they weren't happy, it was an NEC contract. And remember I said there's contract data that you must complete. Usually you will prepare a separate document and have it as a so that you don't have to keep writing on your NEC documents. So this contractor comes and they're not happy with what's happening and they give me their contract. This contract data had nothing in it. Like it was just an empty contract data that was part of the tender documents, and the tender referred to these terms and conditions, but the contractor had never seen them. So they read the tender, oh, the NEC applies, they just submitted their scope and they started building. Now that there's a problem, they're like, okay, contract, which one is the contract? And then they give me this half empty document that they believe is their contract, which means at the beginning of the contract, neither the employer or the contractor cared enough to complete the contract data, and during the project, no one actually even referred to the contract. That's how we're in this position, because no one even knows that there's a contract in place. So you come across a lot of weird things simply because of lack of knowledge and you didn't read properly or something. And then you lose so much money in construction over small things. For example, in the NEC, and Tamlin will touch on this, if you submit a construction claim for additional payments or extension of time and the project manager doesn't respond, you have to remind them. And if they still don't respond, then your claim is deemed to be accepted. Can you believe that? If I've submitted a million rand claim and the project manager just kind of didn't respond, that claim is deemed to be accepted. Now you have to pay me R1 million without having input on this thing. So very, very important to understand your contract. I can't stress that enough. And these kinds of classes, they help a lot. There's webinars online that you can go on to, and LinkedIn, every other day there's a lawyer giving a webinar.
No, we would have, I think I'm going to take a question and take online questions, right?
Thank you very much, Program Director. I'm Zinguazi. My company is Unica Trading and Projects. I think I'm on site. I'm building some houses in Dr. Kenneth Kaunda region in Ventersdorp, which falls, yeah, and I stay in Matlosana. I thought when you threw the question, we would first participate so that our attorney can then come maybe after to sort of now give her professional part, because our law is from the streets. I wanted to come in practically as I grew up within the industry. Fortunately, I've been involved in the low cost housing, which is very interesting and very creative. I wanted to take it actually from even your appointment of your technical teams, your engineering boards. Though they are technical teams, they are not perfect. So I think somehow, take the indigenous knowledge into consideration. For instance, the technical person can draw a plan for you, and when you check the plan is not according to what is needed. So I'm fortunate because I've been having my principal as my government. I think Northwest is very flexible. So I wanted to go to the fact that when they appoint you, first they give you this letter of appointment. That is an intention first, whereby now you check the appointment letter and you come back and say, I agree to the appointment. And then they give you the contract and they give you some days so that you look at the contract. And now you don't even need to go to a lawyer, because lawyers are expensive. We've interacted with the lawyers. And in my space, remember now it's fixed prices, there's no VAT, there's no this and that. But I think it's critical for us, more so us as women, to be intentional. To be intentional, because some of us, for instance, are not able to go to that webinar but I think the networking and that space you give, that seriousness and that growing up, even for women of my age, now I'm able to know that this is not okay, this is okay, because even those people who are lawyers, sometimes others do cut and paste. And you get this and you take it and get excited and you sign. Thus, I'm going back to say, at least my province is nicer and lenient, maybe because it's led by a woman, I'm not sure. Whereby you are given that time to go ABC and consult with the other contractors to say, what is this and what is that? So that's somewhere, somehow, we're able even to consider the issues of contingency, the unforeseen circumstances, your stoppage by your whoever. So I'm saying it's doable, but the critical issue for a layman person like me is to really go deep and check, because we can't afford lawyers with the prices, whereby you can even be given a specification, the quantum that is less than the money you're gonna be getting. So that's my input as at least a veteran in construction. Thank you.
Fair, but sometimes I don't want there to be this big fear of lawyers. At least talk and hear. It's fear of the invoice. Yeah, but the point I'm trying to make. Yeah, absolutely. What we also do is we'll draft the contract for you and also give training to your project team. Once the contract is signed, bring the whole project team so we can tell them how the NEC works or the JBCC or whatever the case may be. So do invest. My point is that there should be a level of investment at the beginning of the project so that things run smoothly.
Thank you very much. It's getting exciting. Can we take questions online? We've got consolidated questions from the online platform, right?
Yes.
Okay. Thank you. Those are online questions that we're taking now. Thank you.
Yes, thank you, Chair. The first one is coming from Mantumbi Siveko. It reads, since the employers choose which contract to use, is it within your right as a contractor to negotiate the type of contract with the employer and decline if I don't reach the agreement?
No, I don't believe there's scope to do that, especially in the public procurement space. Because remember, the employer issues a tender and tells you which contract is going to be used, and then you must submit your response. So there's no real room for you to come back and say, I don't want to use this contract or whatnot, unless it's an RFP, and a request for proposals, where they're saying, you tell us what you're going to do and how you're going to do it. Then it's different. Whereas if it's an RFQ, they'll prescribe, and then there's no point at which you can actually have that discussion. Okay, so once you're negotiating, these are the most common clauses that you'll have to negotiate. So, and we'll touch on some of them a little bit later, but limitation of liability. Has anyone heard that concept? By show of hands, who's heard the term limitation of liability? It's something that you should have heard. Liquidated damages, contract price and payment, the scope, responsibilities of the parties, indemnities, late payments, performance guarantees, force majeure and delivery. So when you get to these kind of clauses, you know you're going to hear something. And the important thing to know about negotiations is that when you are going to court and now someone is fighting about even the validity of the contract and there's an issue, you usually go to court because there's a misunderstanding between the two of you guys. And sometimes the misunderstanding will relate to the interpretation of the contract. One person will say, I thought this is what they meant. And the other person will say, no, this is what I thought. So it's important at negotiation phase to keep documents of what's happening during the negotiation. So, we call it like, we prepare a little schedule, basically, where we'll say, on this date we negotiated, this was what was said about this clause. So that at a later stage, when there's a dispute about, I thought this, I thought that, we go back to our negotiation documents and we say, well, this is what we were discussing, so how could you have thought that? And this case basically says, before you had to look at the document itself to determine the intention of the parties. The Supreme Court a couple of years ago came back and said, you're allowed to take into account the surrounding circumstances. So what happened during negotiation, what was said, and other stuff like that when you are in the dispute at a later stage. So important to know that. And then now we're going to go into the contract, the terms and conditions, before I let Tamlin take over. And I'm going to try to focus on the JBCC here, since it's the contract that you're all most used to. Are there some hands? There's a hand at the back.
There's one more question from
Sure.
the online.
Please.
From Witumelo, it reads, which category does the 10K agreement fall in? Not sure if the question is clear or maybe needs to be elaborated.
Yeah. So you remember you've got your procurement, your procurement strategies. So you've got your traditional, which is construction only. You've got your design and build, and then you've got your EPC and your EPCM. So that's the procurement strategy, and there's a contract related to it. So if you decide that, firstly, it's at the beginning of the project, and that's when you're deciding how you want to implement your project. Do you want the same contractor to do the design and the build, or do you want it to be different? So that's when you'll decide if you want the same contractor to do design and build. Is it going to be design and build, or is it going to be EPC? And that will have a lot to do with the risk and the risk allocation and the pricing and stuff like that. So at the beginning of the project is where you determine all of that. And the EPC is a procurement strategy. The difference is that there's also a corresponding contract. So if you determine that you want to use the EPC, they've already created a contract for you, which is the Silver Book and FIDIC. The EPCM, on the other hand, you have to create a contract from scratch because there's no standard form, but it is a procurement strategy. EPC. Yes. I'm just conscious of time. What's the time? Timer? Okay.
We only have 2 questions from the.
There's another
Oh,
question.
okay, thank you.
There's another question online that says, in the case where a tender documents do not have form of offer and acceptance, as well as contract data, does the absence of this impact the validity of the tender, and is there room for disputes later?
So the tender process is quite a long process, right? There's going to be clarification meetings and stuff. So that's the point to raise that. At the tender clarification meeting, you need to be like, hey, this tender is incomplete. This is what's missing. What do we do? And then they'll give you a response and then tell all the contractors the same response. So you have to engage with the process. You need to attend those clarification meetings. You need to attend those site inspections so that you have as much information as possible. And that's the point at which you can negotiate and things. And I guess if you aren't happy with the form of contract, which is really unheard of, you can raise it at the tender clarification meeting and be like, well, I don't think this contract is in line with the scope you've provided, for example. And then they'll go back and consider it at that stage. All right. Yes?
Okay, let's say during construction of a commercial building, the contractor installs a steel staircase exactly according to the drawing issued by the architect. After completion, it is discovered that the staircase design does not comply with the safety regulation. My question number 1 is, who is normally responsible for the design of the permanent works? And my question number 2 is the contractor responsible for the design area?
So it depends on which procurement method you've used. If you've gone for traditional, it means you're appointing the contractor to only construct. If there's a design error, that's your problem as the employer. You must now go to your designer. Yeah. So what was the first point? The first question was?
My first question was, who is normally responsible for the design of permanent works? And question number 2 is the contractor responsible for the design area?
Yeah, so it all follows from your procurement method. If you've said, as the contractor, you will only construct, then they have nothing to do with your design. The only thing they have to do is look at your design and interrogate it to make sure there are no obvious defects. Even if they're not designing, they still have to do that. But other than that, if you are only building, you're not liable for design errors.
Okay.
It's only when you're the design and build contractor.
Okay.
And then a design and build contractor can either be a design and build, or it can be for the EPC. That's also a form of design and build. Okay. So here, we're going to talk about the contract becomes very important at the execution stage, because that's when every other minute you need to look at your contract, what it says you need to do, by when you need to do it, and stuff like that. So this was why it was horrifying when that client came and there was a dispute, and it was very clear to me that they had never seen the contract before. And then I was wondering what's going on site. But so here I'm just going to talk about the different types of contracts. The first important party, other than the employer and the contractor, is the contract administrator. So under the JBCC, under FIDIC, it's the engineer. Under the JBCC, it's the principal agent. Under the NEC, we call him the project manager. And the GCC, we call him the employer's agent. So he is appointed by the employer under a separate contract, a professional services contract. And he administers the contract on the employer's behalf. So he's not a party to the contract, he's just the administrator. So he has no authority to amend the contract, no. He just administers it. The important thing to know about the contract administrator is that during the project, they wear two hats. So the first hat is as an agent of the employer. They are here administering the contract on behalf of the employer. So they are issuing instructions, issuing variation orders, and dealing with contractual communication. And here, when they are acting as employer's agents, they need to act in the best interest of the employer because they are appointed to administer the contract on behalf of the employer. But there are certain instances in the contract where the project manager's actions or the contract administrator's actions are no longer, he no longer wears the hat of acting in the employer's best interest. He's now wearing a quasi-arbitrator hat. So in all of these contracts, there'll be instances where if something happens on site, you have to refer to the engineer to make a determination. When he's making a determination, it's like he's acting as an arbitrator, quasi-arbitrator. He's acting like a judge, and he's giving this decision. And when he's acting as, he's making a determination, making a decision in terms of the contract, he's not supposed to act in the best interest of the employer. He's supposed to be an independent, neutral third party who takes into account both sides of the story and makes his decision. So remember, when you're administering the contract, issuing instructions, correspondence, variations, you're acting in the best interest of the employer, you're acting as an agent. When you are making determinations and assessing claims and assessing payments, you are acting as a quasi-arbitrator. The important distinction here is that when you're acting as an employer's agent, you can be sued for acting negligently. So for example, we spoke about how under the NEC, if the project manager does not respond, we spoke about under the NEC 3, if the project manager doesn't respond, the claim can be deemed to be accepted. So if you as the employer felt that was a negligent act by the project manager of not responding, there might be room. But so the important thing to know is that in one instance they can be sued, in the other instance they cannot be sued. Like the same way you can't sue a judge, you have to appeal his decision. Same way you cannot sue the engineer when he's acting as a quasi-arbitrator. You have to take his decision to dispute resolution. And Tamlin will go into that. Another important party in a construction project is a subcontractor. And you get different types of subcontracts. You get the domestic subcontractor, which is your normal subcontractor appointed by the employer. Appointed by the contractor. The contractor is responsible for all of his work, and usually there's an established relationship of trust between the contractor and the subcontractor, and they work together on projects. Cool. And then you get the selected subcontractor. The difference here is that this contractor is selected in consultation with the employer. So the employer kind of gives a recommendation. Doesn't force the contractor to appoint him, gives a recommendation, you consult, and then you decide. So here, the contractor still remains responsible for the contractor because it was in consultation, you weren't forced. And this is generally for specialized services where, the employer wants the best guy in the market and doesn't want to leave it up to you completely to do this, then you'd kind of have that kind of arrangement. Then there's a nominated subcontractor. This is where the employer selects the subcontractor. They force basically this subcontractor onto the project. And the contractor has very limited right to object. They can object on the basis that, they're in financial difficulty, it's all over the news or something like that, but there's very limited reasons to say, no, I don't want to use this subcontractor. One of the things you need to know about subcontracting is that you cannot subcontract the whole of the works. So that would be kind of fronting, if you tender for a project, but you have no specialities and you're going to subcontract all of it. That's not allowed. And then you also need to remember that when you're dealing with subcontracting, you need to make sure that the main contract and the subcontract are aligned. So if you have to submit a claim within 20 days under your main contract, make sure that the subcontractor under subcontract has 10 days to submit his claim, because his claim is going to be part of your claim to the employer. So the contract has to work like that. All the provisions must be back to back with the subcontract. If there's an obligation under the subcontract, then it must be aligned with the obligation from a time and requirements perspective with the main contract.
I want to specifically dive into the nominated subcontractor, because the nominated subcontractor is selected by the employer. So as a contractor, you have really limited rights to object. And in instances where you find that because they are nominated by the employer, they do as they please in most instances. Yes. Within a confinement of a contract, if you go back, you deal with scheduling, where you have activities that depend on other activities. And sometimes you find that they hold you back in terms of you being able to implement the project on time or meeting the timelines, because they just, though they're under you, but they came through the employer. How then do you deal with these issues of nominated subcontractors that are not really coming to the
Performing. Yeah. So with nominated, ordinarily under subcontracting, if the contractor subcontracts, they remain responsible for everything the subcontractor does as if they didn't subcontract. When it's a nominated subcontractor, because they acknowledge that you were forced, this situation was forced upon you, then there is a level of liability that the employer also assumes. So you have to look at your specific contract, and if you are not happy with what the contractor is saying, you have room to amend it, because once you hear the term nominated subcontracting, there must be some level of liability on the employer. So you need to look at the contracts. The standard form contract will probably have it drafted in, but if it's a bespoke contract, you need to make sure that you are able to bring the employer into that dispute.
Maybe I must ask this question differently. Have you come across any issue that related to a nominated subcontractor that has resulted in the project being delayed, or the performance issues, or there are other risks that are associated with dealing with a nominated subcontractor because they think they've got upper powers?
So this is something we were going to go into with claims and delays. So the 2004 JBCC, which I think a lot of people work on because it's basically the state version of the contract, doesn't address this as well as the later versions of the JBCC. So the 2004 version basically says, let me go stand over here. Hi, I didn't trip, yay. So basically the JBCC 2004 edition, right? And this is very important. If you are delayed in achieving practical completion, there are 3 categories in which you can apply either for an extension of time with an adjustment to the contract value, or there's like a catch-all where it kind of gets a little bit murky. So the 2004, unfortunately, when it was drafted, said that's nominated subcontractors, if they cause delay, you're entitled as a contractor to an extension of time without cost, right? So you won't be penalized, but you'll still take on the financial burden that's occasioned with the situation. And obviously you can take that to dispute. When they rewrote the JBCC, they amended that, and a nominated or direct contractor appointed by the employer, if they cause a delay, entitles you to both an extension of practical completion as well as an adjustment to the contract value, which is obviously what we want for contractors, right? If the employer appoints someone, they delay you, it's not your problem, not your fault. So there is where there's a bit of a discrepancy and where a problem comes in. And I've heard from a number of contractors that the state obviously favors the contract that says they don't have to give you that cost adjustment. So at the point of you receiving that letter of appointment, it is optimal if you send a letter back to the employer and say, listen, I'm not happy with the way this is. We understand that this is the contract. However, can we negotiate? So either, as Zama said, you do that at tender stage with your deviation schedule, which I understand as a contractor, especially as an emerging contractor or as a female, and I mean, I get it. Being a female attorney, you stand up against old men who've been doing this for 40 years and think they know it all. You know the ones I'm talking about, right? So it's up to you at that point to make a note of the problems and check your contract, specifically a tender document, because there's a couple of government/parastatals who in their tender documents specify that you may not deviate. If that is the case, you need to be aware of what your contract says. So you either need to go through that contract with a fine-tooth comb and accept that you are happy with the risk, or you may have to submit a deviation or decide to walk away from that work, which no one wants to do in this economy, realistically. So what is imperative as a contractor is to make sure that the first thing you consider with a tender is what, as Amma said, what contract are you dealing with? And while, I mean, we were preparing for this, I think we looked at the various contracts. Obviously, the claims and dispute procedures are going to be significantly shortened because we're going to go on with the JBCC and how you would work that process, because the process changes, but the fundamentals stay the same. And I mean, I don't know if I've answered the question at this point.
Are you guys happy with that? I'm happy with that. Go. Okay, I'm gonna quickly rush to my. Oh, this is yours. Yeah. Quickly rush to the section, and then we can get. So now I just wanted to touch on the construction principles, that terms you'll hear about on a construction project, and then go into how they are dealt with under each of the standard form contracts, and specifically focusing on JBCC. So one of the most important things are the security forms of security in construction contracts, because they affect finances and performances in relation to the project. So you've got they are referred to security, guarantees, bonds, different names used under the different contracts. The types of security you'll get under construction project are performance guarantees, retention guarantees, advance payment guarantees, and a parent company guarantee. So I think I actually, before I go into the definition of each of them, let me just tell you the different types of guarantees you'll get. You can get an on-demand unconditional guarantee or a conditional performance guarantee. So if you've got an on-demand unconditional guarantee, it's basically a guarantee from obtained by the contractor from a bank or an insurer that says if the contractor fails to perform under the contract, we will pay you an amount of XYZ so that you can find someone who can complete it and pay them. So that kind of document can either be on demand or conditional. If it's on demand, it means that I don't need to go to court and prove what I've just said. I'm telling you that I need to just provide a statement saying what's happening on site and how the contract has been breached. And then in terms of the obligation and under the bond, you need to pay me. Whereas if it's conditional, it basically means if I have an issue, I first have to go to court and get either a court order, an adjudicator's award, or an arbitrator's award before I can make use of this performance bond. So different types of bonds. The first one is a performance security, which, as I've said, it's about your performance under the contract. If you have not performed, the bank or an insurer will come in and pay the employer for your failure to perform. Basically, I've copied and pasted the FIDIC provisions which relate to this, and they are the same, substantially the same in most of the agreements. So I'm just gonna go to the JBCC. Clause 11, and so I put the NEC there, the GCC, but I'm just going to focus on the JBCC in the interest of time. So the contractor shall provide to the employer a JBCC guarantee for construction within 15 working days of acceptance of the contractor's offer. So after that letter of acceptance, you as the contractor have 15 days to go to a bank or an insurance or an insurer to get a performance bond if it's required by the contract. I believe that you're not entitled to any payment until you've done so under the JBCC. So it's very important that you do that. There's similar clauses in all the other contracts as well. And then you have a retention. So you've got your performance guarantee, which relates to performance. Then you've got your retention guarantee. And in engineering contracts, the employer can withhold a percentage of the payment to the contractor in order for that withheld money to be allocated towards the remedying of defects in the project. So that amount, we call it retention. So basically at the beginning of the contract, you'll agree that with each interim payment, I'm going to retain a percentage, and you'll agree on the percentage. And then you'll also agree of the maximum amount of monies that can be retained. So I'm only going to retain 1% of each interim payment to a maximum of 15% of the price. That 15% of the price will go into a little retention fund thing, and when there are defects on the project and the contractor does not remedy them, it's security for the remedying of defects. So if the contractor is not hearing you, you just go to your security and you take that money and you go remedy the defect yourself, or you pay a third party to do so. So it's a way for you not to have to be at the contractor's mercy you have a form of security if they're not doing that. So typically, retention is withheld throughout the project and used towards remedying of defects at practical completion or taking over, depending on which contract you're using. 50% of that retention money must be given back to the contractor. And that's because at this point, the risk of defects cuts into half because the project is near completion. But because you still have your defects liability period, which starts at completion, you still have the other half of the retention monies to cater for any defects that arise during that period. And then once the defects liability period is over, you then give back the retention monies that are remaining. Or if you've provided a bond, sometimes you don't have to retain physical cash, you can provide a retention bond, which will cost you money too, but it's better if you want your full invoice to be paid. Smaller contractors do not like cash retention. I don't think anyone does, but yeah. So under this arrangement, the guarantor, an insurer, or a bank says, "I'm going to pay the employer X amount of money if the contractor fails to remedy defects." So you agree that amount of money, the value of the bond, you agree at the beginning of the contract. So it's usually an amount or a percentage of the contract price. So all of that is determined then. And then I've just copied and pasted or summarized the different clauses in each of the contracts that relate to retention. And they all say the same thing. They say you withhold your retention amounts at taking over, you give 50% back, you use the remaining 50 during the defects liability. At the end of the defects liability, you give the rest of it back or the bond. You've also got am I almost done? Oh, then you've got an advance payment guarantee. This is used to basically, if the contractor needs money before the contract has started in order to allocate it towards resources required for the project, that's advance payments. The important thing to know is that if the contractor wants advance payment, you must require them to give you an advance payment bond because that is security for their repayment of the advance payment. If they don't repay it, you can just go to the bank and say, "I gave this person this amount of money in advance payments. They haven't paid it back, and your bond is a form of security that you can use." And so I've just copied the clauses of the contract that deal with advance payments. And then you've got insurance, different types of insurance. Your contract has all risk insurance, professional indemnity, product liability, public liability, and special risk. The most important is the contractor's all risk insurance, which covers physical damage or loss to the works on site. Usually the contractors will be responsible for providing this insurance because they are required to have this insurance in the ordinary course of business. But for mega and major projects, you might be required to take out project-specific insurance in the joint name of the parties because the employer will be afraid that your insurance won't be sufficient. Another important one is professional indemnity insurance. This is where you have a principal agent who has been negligent and you want to sue them. It's important for them to have professional indemnity insurance to cover that liability. So you can act against a principal agent. Very important for them to have PI insurance. Limitation of liability is a total of all the liabilities the contractor can incur under the contract. You need to have agreed this at the beginning of the contract. Well, you guys are all contractors, so this is more important for you. You need to make sure the employer limits your liability under the contract. Otherwise, you can be sued for anything and everything that the contract allows. But this says, for example, all the contractor's liabilities under the contract will be limited to 100% of the contract price or 10% of the contract price. So you can only sue the contractor up to 10% of the contract price for anything that you want to sue them for in this contract. So it's important for contractors to have that limitation. And then within that limitation are certain exclusions. So consequential losses which are not an ordinary consequence of what we're doing, but an exceptional consequence of the breach. So stuff like that is excluded from the cap on liability. I'm just rushing through things now, but you remember the principle of risks, where we said you can't create a risk and then pass it to someone else. So here as well, you cannot limit liability where you have perpetuated fraud or gross negligence or deliberate default or reckless misconduct. You can't then say, "Oh no, but my liability is limited." In the case where there's fraud or negligence or gross negligence or whatnot, you can be sued to the full extent of the law. Also, when you're calculating that limitation of liability, remember that there's also the bonds and the insurances. So those amounts must be taken into account when you're calculating your limitation of liability. Then we have variations. This is where you change your scope of work. So the important thing to know about variations is that you can pretty much change anything about your scope of work as long as you do so before taking over, before practical completion. And secondly, the main thing is that you cannot take away the scope and give it to another person because the contractor has tendered freely for that scope. So you have to give it to them. The only time you can de-scope someone is if you no longer need the scope, not to give it to someone else. That's a breach. So that's
Or
the
if they've
important thing
not
to know about
performed.
variations. Each of the contracts have a different procedure. Understand that you have grounds to reject a variation on the basis of health and safety or lack of materials, or it will affect the performance of the final facility. Another thing to know about variations is that it's not always instructed by the employer. The contractor can also submit a proposal. It's called value engineering, where you submit a proposal saying, well, I've got a better idea on how to execute this. And then you give it to the employer. And then if the employer agrees, then they turn that into a variation of the contract scope. Force majeure events. What's the most important thing to know about force majeure events?
That it's usually shared. It's a shared risk. So you'll generally, with a force majeure issue, you will get cost without time. What I am going to say to everyone, because obviously this is a question that's going to pop up, the fuel issue currently being faced by contractors is an example of a force majeure risk generally covered under the contract under like a war or a riot. However, what I will say is looking at I'm just looking at the contract now specifically. It's one of those things where we spoke about sharing risk. The employer can't help if there's a war that's broken out. But unless you have signed a turnkey project, your best solution is to actually speak to your employer and say, hey, listen, neither of us made provision for this. Can we reach an arrangement? And this is something that I think a lot of parties to a contract don't remember, is that when you sign this contract, you're getting married to someone, in essence. That's the example I use. And there are two ways a marriage ends: death or divorce. Right. We all hope for death next to our partner. Sometimes. But for the most part, there has to be a way out. And you have to, in order to keep a marriage going, you have to communicate. And people seem to think that you can't do that. So force majeure events are generally shared, but you can always negotiate during a contract to say, hey, listen, can we be a little bit more reasonable on this? But I do want to just double check that I am being correct on this.
She means shared in that the contractor will be absolved from performing from a time perspective, but
Yeah.
each party carries their own costs, like the employer won't be held.
Yeah, so also they'll get practical completion will be extended, so you won't face penalties, but you will still have to pay your staff, etc., for that time.
Thank you very much for that. We have an online question. Thank you.
Okay, thank you. So there's an online question and it says, if you find after a tender award that the BOQ, in terms of days as units, differ from the scope of work, units in hours, causing a price discrepancy, how should this be addressed with the client under the GCC 2015?
Under the GCC 2015. So I'm sorry, please just the difference in your BOQ. Please repeat the question quickly.
Okay, so what they want to know is in terms of the BOQ, where they've got the period is in days, and then from the scope of work, the units is actually in hours.
Okay, so for me, we don't even need to get to a point where the contract is signed and we need to go to court or whatnot. At your clarification stage is where you're supposed to have picked all of this up. And that's when you submit a clarification, drawing the employer's attention to that. And then the employer will tell all of the contractors what the correct position is. So very important to engage with the whole procurement process and not just think that mine is to come and do the work. But let me just complete. Does that answer your question? Okay. Okay, perfect. And then just to touch on completion, and then I'm done. I just want to I'm going to go through it in general. This is FIDIC, but generally speaking, this is how it works. You've got the relationship between defects, liability, retention, and completion, which I've spoken about. And then before you can say you're done, practical completion has been reached or taking over has been reached, you have to have submitted your as-built documents. So remember, you have drawings at the beginning of the project. You have to submit the drawings at the end that show what was actually built. So you have to have submitted your as-built documents. You have to submit your operating and maintenance manual telling the employer how to use this facility. You have to have completed and passed all your tests on completion, and you have to have completed any contractor training that is required by the contract. And only then can you apply for your taking over certificate or your practical completion certificate. And that's a process of coming to inspect the sites and taking down a punch list item, a list of punch items that you need to complete before we can say completion has been achieved. You complete the punch items, and then completion has been achieved, and then defects, liability, and so on, and retention apply. So it's basically the same, relatively the same under each of the contracts. And then you've got your remedies for breaches. Specific performance is where you go to court to say, I want you to force them to perform their obligations under the contracts. They're not performing. Maybe the contractors abandoned the site and you don't want to terminate the contract. You want them to perform. That's called specific performance. You go to court and you request an order to that effect. Then you've got repudiation. Repudiation is when a contractor abandons the site and indicates an intention no longer to be bound by the contract. If the contractor repudiates as the employer, you have two options. You can accept the repudiation and say, okay, fine, and then terminate the contract, or you can reject the repudiation and then claim specific performance. So I see you've abandoned. I'm not trying to hear it. Come back to site and complete your responsibility. You can get a court order to that effect. And then termination for material breach. A material breach is something that goes to the heart of the contract. Okay?
So like payment.
Yeah, payments, if you have it, yeah, payment is definitely one of them. And then termination in terms of the contract. Each of these contracts lists grounds, specific grounds for termination. For example, corruption, failure to provide a performance bond by this date, long-term force majeure, there's certain grounds. And then damages. So when you terminate the contract prematurely, you're allowed to claim damages. Damages is a financial amount that seeks to put you in the position you would have been in had the breach not occurred. So that's something that is calculated. And then another remedy is that of liquidated damages. Liquidated damages are pre-agreed amounts of penalties that are payable by the contractor for either failure for delays, failure to complete on time, or quality issues, so low performance, failure to provide something in accordance with spec. You can pre-agree an amount at the beginning of the contract that if that happens, this is the amount that you're paying per day or per week or per whatever until you are in line with the program, or in the event of low performances until you pass the test. So yeah, I think another thing to remember is that with any damages that you face, you have an obligation to mitigate your losses. So when you start suffering losses, you have to find a way to make those losses less. You can't just sit back and let them accumulate. The law requires you to, even if the loss is not your fault, find a way to make the losses less. And these are just some of the clauses that you'll come across in your contracts that are important for contract management. Key personnel, basically having the same personnel stay throughout the project, because when there's a dispute, your witnesses are all over the world and other projects. The program is an important project management tool. Progress reports provided on a monthly or whatever basis. Value engineering we've spoken about. A right to audit clause allows the employer to come in and audit the contract or audit the contractor's performance at any point. So that's important. And then acceleration is when you pay the contractor to fast track the works. That's a clause that can help you. And then interface and cooperation, letting the contractor know that there are other contractors on site and they need to manage their works in a way that will collaborate with these other contractors. So yeah.
Thank you very much, Zama. That was really insightful. I think we've learned so much about the different types of contracts. Can we give Ms. Zama Ngobo another round of applause? Thank you. We'll now make welcome Ms. Tamlin, who's really eager to get on the stage. We're really thrilled to have you come on board to talk to us about dispute resolution and claims from the same company, WMN. Tamlin is the senior associate. Okay. Over to you. But colleagues who are joining us online, I would like to really encourage you to send your questions, your comments, so that we can take advantage of this opportunity. Whilst we have the lawyers free of charge in the room, they're not going to be invoicing you. I'm told CIDB has already paid the invoice. So let's take advantage of the fact that we have them in the room. If you've done a project or you're currently doing a project, you are going through some challenges, please put them on the chat box. Let us get answers for you on how you resolve the dispute that you currently are facing. Thank you very much. Over to you.
Thank you so much. Apparently, I am short. So I'm going to make this as practical and as quick as possible because I know everyone has things they need to do and that we are potentially going over time already. And given that this is going to be more JBCC focused, we are going to probably breeze through a lot of these slides anyway. I just want to find the clicker. So first and foremost, we look at claims. Am I speaking slowly enough for people to hear first? Yes. Am I? Perfect. Okay. It is very difficult for me to stand still while I'm speaking. I'm used to walking up and down a lecture theatre. Oh, perfect. Okay. Well, I will probably pick that up at some point. So basically, we have to look at claims under a construction contract because for a contractor and for an employer, but mostly for a contractor, this is incredibly important because we know that construction very seldom goes as planned, right? I'd like you to put your hand up if you have achieved practical completion on the date that it was first stated in the contract. Anyone? Anyone online? Right, it never happens. And what happens if you don't achieve practical completion is you get penalized, you have costs that overrun because we have staff that we need to pay as a contractor, you have supplies you need to buy. So this is where claims come in. But we need to first decide and distinguish between what is a claim and what is a dispute. And a claim is simply a written demand where you are seeking relief under a contract. You want something that you are entitled to, whether that is time, whether that is money, whether that's a pat on the back. You are asking for it and asking them to give it to you. A dispute, however, is when you have made a claim or you have requested something and the other party has said no, you're not entitled to it or just ignored you flat out. So we're going to focus on the JBCC and how that claim procedure works. And it is unfortunately not like the NEC where claims are deemed accepted without a response. In fact, it works in the opposite direction. So these slides focused predominantly on the newer versions of the JBCC, which is why I have my trusty little notebook here, where I've made tiny notes. And we're going to ignore all of that because as much as we need to know it, we don't need to know it right now. And you are welcome to come and ask me about this later, and I'll give you a whole lecture on it, gladly. The GCC is also quite important, but we're going to go on this slide. Right. Now, the main point of the slide is to show you how a claim arises. However, don't necessarily look at the clause numbers or the entitlements because this is the edition 6.1 and 6.2. And how many people are currently working on a 6.1 or 6.2, the 2018 JBCC or the 2014? You've worked on it. Everyone else, I assume, is working at about 2004, 2005, somewhere there. Specifically, the edition that has that lovely little hash sign next to clauses. I'm not sure if anyone's seen that. Okay, so the March 2005 edition of the JBCC, which is what a lot of government institutions and parastatals use currently, is a state edition, which means that it has clauses inherently meant for a project, but any clause that has a hash sign next to it, like the cool kids go, you know, hashtag blessed, stressed, impressed, whatever, that clause at the back of the book has a specific state-friendly provision, which if you don't monitor your contract and if you haven't read your contract as a contractor, you won't know that that provision applies. So the first thing you do when you get a tender is to look at the edition that you have of the contract. Is it a state edition? If it is your employer under the contract a state entity, SOC, parastatal? And if so, have they made, and whoever the employer is, have they made any amendments to the specific terms and conditions? Because today, we're speaking specifically on the contract, the standard form as it is printed and published. We're not discussing what happens when a lawyer for the employer gets hold of a contract and amends it to the employer's benefit, because we understand that that happens. We understand that commercially, the lawyer is going to make changes that are going to be for the benefit of the employer. So the older JBCC, which I think is what most people are working with currently, had 3 categories of claims. The first being an extension to the date for practical completion without an adjustment to the contract value. So you get your days, you don't get penalized, but you are still liable for costs. The reasons that would happen would be inclement weather, which is now changed to adverse weather, inability to obtain specific materials and goods, making good physical loss that is at the contractor's risk, because when you take over the site from the employer, you become responsible for specific risks. Vis major, which is our force majeure effects now, as we said earlier, the late supply of a prime cost item, or the default of a nominated subcontractor. And I said to you earlier that the default of a nominated subcontractor being in this particular category is not an ideal situation for a contractor. You don't want that in this clause. Ideally, you would take that out and put it into the second clause, which is clause 29.2, which gives you an extension of time to the practical completion and costs. Those are things such as a physical issuance, contract instructions that were late, a suspension or cancellation by a subcontractor, insolvency of a nominated subcontractor. For some reason, that falls under this category. Actions of a direct contractor or testing where work is opened unnecessarily. So your principal agent says to you, that work is not within specification, please open it, let's test it. And the tests come back and say, well, hey, Mr. Principal Agent, actually, the work was correct. That would obviously entitle you to extension of time plus cost. Any additional work that is requested and is not adequately covered by the BOQ, and late or failure to supply material where the employer is responsible for that. Your third category, which differs from the newest JBCC, is a catch-all category. So it's any incident, event, etc., that's beyond the contractor's control that a reasonable contractor in the position of the contractor in that contract would not have been able to provide for. But what is most important when you have a contract, when you get your JBCC, is not only to see where these events fall into, but what your timelines are. Because many contractors lose the right to claim under the contract due to things called time bars. So time bars are included in contracts to put a limit on the amount of claims that can go through or that the employer is subject to. And the JBCC is particular in the way it handles the situation. The JBCC doesn't specifically require you to give notice when something happens. It says when you became aware or ought to have become aware. So as a contractor, you have to have forethought and think, oh, I didn't actually become aware of this delay on Monday. I should have become aware of it on Friday last week when someone said to me that, the clouds over there are looking a bit dodgy and the weather's potentially going to be bad. That's a simplistic example, but things like riots and strikes, you have notification of it. And you have 20 working days from when you became aware or ought to have become aware as a contractor to notify the principal agent of it. The newer versions of the contract go and say that you have 40 days from when the delay ceases to give your claim or an interim claim, depending on if it's an ongoing situation. You have 40 days to give the principal agent notice of a claim and the effects of the claim from when it stops and when you could quantify the claim. The older version says 60 days. as a contractor, go and look at these dates. Go and look at the 20, the 60, the dates, the times, because that is where contractors trip up. Because often these are dates that the employer will change to suit their method of working. Standard timeline for principal agent to reply to a contractor on a claim is 20 working days. So he has 20 working days to either refuse your claim, accept your claim, or respond in an amendment of your claim, and the response must be in writing. If he fails to do so, unlike in the NEC, it is deemed as refused. And this is where, again, contractors fall short. The minute your claim is deemed refused under 29.8, because your principal agent hasn't said anything, and of all the problems on a contract, it is very seldom that the principal agent said something. It's most likely that the principal agent has failed to say something. They just kept quiet. At the moment that that principal agent fails to say something, you automatically have the right to take that to dispute. But you have a time period in order to do so, which we're now going to focus on. So I'm going to go into dispute resolution because that's your next step. So as we've said, dispute resolution under contracts and construction contracts there are a variety of options. So I think everyone knows about going to court, which is known as litigation. It takes time, it's expensive, the courts are overrun, and genuinely the idea of going to court as a contractor is terrifying because of the amount of money, one, that lawyers sometimes charge. Not us though, we make agreements. And the time that you're going to spend in court and that you're going to have to spend away from your business and away from site. So as a result, we've come up with, or really, really smart people within the industry came up with alternative dispute resolution. So it's an option that circumvents the court and provides the parties with a recourse that takes less time and allows for cash flow. So of the three options, you have amicable settlement, which is always option number one, is you talk it out. And the JBCC deals with that in section 40 specifically, where it requires the party who is upset. So if you have not heard from the principal agent and your claim is deemed refused, you have a period to then give notice to the employer and the principal agent where you say, hey, listen, haven't heard anything, time has run out, please can you respond? Once you send a written notice outlining that, the clock runs for 10 days. You have 10 days by which point you are supposed to resolve that disagreement, failing which it automatically becomes a dispute. You then issue a notice of dispute, which will send you, in terms of the older JBCC, to adjudication, and the new JBCC also prefers the option of adjudication. Because an adjudicator, unlike a judge, has to listen to both sides. The concept of natural justice and everyone gets their side is heard. He focuses on what's presented to him and he has a specific period of time to do so. Most of adjudications should take place in writing, on the papers. It is not intended to be this long mini trial. It has unfortunately become that way. And the new JBCC has dealt with that by specifically saying that parties may not be represented unless they've agreed to otherwise. But just because a contract says that you may not be represented does not mean that there is not a lawyer working in the background, drafting papers and helping and assisting and giving advice. As long as a lawyer's name doesn't appear, that is how you would get around that particular clause. And the idea behind this is that currently, and the adjudication purpose, is that it is a binding decision by an expert or by someone who is within the field that you can then enforce until and unless it is overturned by some other form of dispute resolution, generally an arbitration or a high court judgment. And the newer contracts have specific clauses in them which say that an adjudication decision is binding up and until it's overturned, which means that even if you don't agree with the outcome, you still have to abide by it until you take it to arbitration. So Mr. Contractor goes to his employer. The principal agent rejected his claim for 2.5 million rand. The adjudicator finds, whether incorrectly or correctly, which is a chance you take, that the 2.5 million rand should have been awarded to the contractor. The contractor is then entitled to enforce that, even if the employer takes it to court or to arbitration, unless that additional forum says that the adjudicator was incorrect. So in the 3 years that it takes for you to get a judgment in a court or in an arbitration, you have access to that money and the project continues. I will say that there are obviously pros and cons to this. The con being that if you find yourself on the opposite side and you have an adverse decision against you, you will then have to enforce that decision. And if you choose not to, they can take you to court over it. The other option is arbitration. And I mean, we'll go through the causes of construction disputes, but I think this is a fairly common issue. The other option that you have is arbitration, which is basically a private trial. The parties select someone, either a retired judge, an accountant, who has experience within a topic, and then there are specific rules that are applied. So you bring evidence, you bring witnesses, you prepare, and the reason people often opt for arbitration is that you avoid things like postponements because court is too full. You do not, however, avoid postponements because your opponent has pulled a trick, because again, arbitration generally require lawyers, and lawyers can sometimes complicate things significantly. We try not to. We honestly do. I promise. I try not to, and Zama tries not to. But it's our friends from way back when that like to. It's also generally men who like to complicate issues. And lawyers, especially when you are dealing with an employer who has deep pockets, tend to find ways to make proceedings longer because it means you have to pay more. So at the beginning, and this is sort of just a hint, at the point where you are entering into a contract, because again, adjudication is a contractual right, whereas arbitration is a legal, it's enforced in law. An adjudication decision is enforceable by contractual agreement. So if you've agreed to adjudication as your remedy, you will sign a contract at the beginning appointing your adjudicator and agreeing to how that procedure is going to go. So I'm gonna carry on into arbitration a little bit more, but does anyone have any questions? Yeah. There's one in the front.
Thank you. There's an online question. It's more on claims.
Yes.
It says, in an instance where there's a riot on site due to the contractors not paying laborers or subcontractors, can this delay still be classified as a force majeure?
No. So if the contractor is not paying its laborers, that is a contractor-created problem. And one of the fundamental concepts is that you cannot benefit from your own cause and effect. So if you've created something, you can't benefit from it, basically. If I'm not paying my contractors, my laborers, and they strike, I can't expect the employer to then not penalize me for that delay. So that would be a no. Unless it was the employer not paying the contractor that led to the contractor not being able to pay its staff, in which case it's slightly different, obviously. So I'm not going to go into all of these things. These are quality performance, acceleration, payment, administration, deviations, and extension of times are all things that lead to disputes. Are there more questions online?
There's more questions, yes.
Perfect.
There's
Yeah.
another one that says, where there is no retention applied in the project, how does the client enforce a 3 months liability period? Will I be bound to repair or providing a written 3 months suffice in protecting the client? I don't know.
Okay, so hopefully I'm getting this right. So there was no retention provided. So first and foremost, the way that the JBCC deals with retention is if you don't provide a bond or security, you automatically, as the employer, you're entitled to take a percentage of the contract price and hold it until you get to a specific amount. But even if that doesn't work and you don't have a retention, contractually as a contractor, you are required to ensure that the works are completed free of defects, both patent and latent, which we can discuss at a later stage. So if your work is defective, they can, and you refuse to fix it, they can put you in breach from a common law point of view, and then they can appoint someone else to fix those defects and then sue you for the damages, basically, and the cost of appointing and fixing that work. So I'm assuming that is it's not a great remedy, but it's there.
There's another question.
Okay.
It says, good day. How can I deal with the scenario where I attended on a civil project without being aware of a BCCEI rate, and I'm required by the BCC inspectors to pay employees using the BCCEI rates? I'm not sure if.
So I would say that that's not necessarily a construction-specific question. That's more labor-specific question. However, under a construction contract, you are required to comply with all of the country's laws. So if there's a specific rate in which your staff is supposed to be paid, as an employer, you need to be aware of that. And I would probably seek guidance on what the difference is and either enter into an agreement with your staff to back pay the required amounts, or you may find yourself on the wrong side of an action, which no one wants at this point.
So we spoke about changes in the law. I spoke about changes in the law. I spoke about changes in the law. So if you have a long-term contract, that could, and you anticipate rates or something being increased during that period, it would be helpful to have a change in the law clause, because then you could claim back from the employer whatever increase. For example, during COVID, there were all sorts of responsibilities that were added onto contractors. The cost of that compliance, you could claim back from the employer. So
yeah, well, that Zama's correct.
It depends on when the change happened and what your contract says.
Yeah, so a lot of what can often happen is if it is a long-term contract, or if it's even just like a 2-year contract, you'll have a date at which no changes of law take effect, and then after that period, you'll have it's laws that specifically affect the works. That's how often, the compromise is. If it directly affects how the work is carried out, then you're entitled to claim for it. But let's quickly go through the different types of settlements. So I mentioned amicable settlement, right? You guys either sit and talk together, which is just around the table without prejudice meetings. You can do it yourself. You reduce it to writing. Happy-go-lucky. That then becomes basically a contract. A settlement agreement is another form of a contract. And you can then take it to court at a later stage and be like, hey, they're not listening, or to adjudication, depending on what your contract says. The other option is mediation. Mediation is where you sit in a room with an independent third party who doesn't make a decision. They guide you on the path to making a decision. So for instance, Zama and I enter into a construction agreement. I installed the doors upside down. And now I don't want to fix the doors because I think it looks aesthetically pleasing. We don't want to go to a lawyer because we think that we can come to some sort of agreement. So we go to Mr. Smith and we say to Mr. Smith, we don't want you to make a decision. We just want you to guide us there. He will speak, he will talk to us, he'll ask questions, he'll look at the evidence, and eventually Zama and I will either come to an agreement where we say, okay, actually, I realize that I probably should put the doors the right way because it's going to confuse everyone. And ideally, you then write that down and reduce it to writing again. Because the best piece of advice I can give you from experience is write everything down. Paper trails, write everything down. It's very difficult to disprove something if you have it in writing. And then if those things don't work, then we head to adjudication and to arbitration, which I've spoken to you about, which is more of it's more legal slanted, but it's different to going to court. So adjudication, as I said, you have an expert, he gives a decision, binding until overturned, arbitration is a judge, etc., etc. The older version of the JBCC, right, says you give notice of disagreement, 10 days to resolve, as I said. If it's not resolved, it becomes a notice of dispute. You then refer it to adjudication under the rules applicable at the current time. So every contract will have a specific set, every standard form contract anyway, has a specific set of adjudication rules applicable to that contract and how the adjudication should run. Unless you've picked something else because you want it to be different, and that's a different story, and you need to know what those are. So you get your contract, you look at your deviations by the employer, you look at the rules applicable in dispute, and you look at what they've selected as the dispute procedure. It is then binding. So it is a binding decision from an adjudicator, and the other option that's provided in the 2005 edition is mediation, but you have to have referred it to mediation within 15 days of the dispute being declared. But what is not fun is that in the state version, which is this 2005 version, there's a clause 40.2.2, which in the original contract, there's no clause. It says no clause, but if you go to the document and you look at the state clauses, which specifically says that the employer can elect litigation as its form of dispute resolution. So the employer can decide to send you off to court to fight about this, and you have to have instituted action and commenced any procedures relating to this within a year of the date of the dispute coming into existence. Anyone who works within the legal field knows that complicated matters take time to get to court. And as an added bonus to this, there is an act called the Institution of Legal Proceedings Act, which says that before you are able to institute proceedings against an organ of state, you have to give them 6 months written notice. So, if they have elected this, you are potentially going to be faced with a situation where you have less than a year. And obviously, if this is the solution or this is the selection that the employer has made, the rest of the procedures and provisions relating to adjudication falls away. Under the JBCC, if you are not happy with the adjudicator's decision, you are then able to refer the matter to arbitration. But arbitration is not necessarily a review of his decision. You're not going to an arbitrator and saying what he said was wrong. You're in essence restarting the whole process from scratch. So you are able to, your claim will remain the same, but you are now able to bring new evidence, you're able to bring in witnesses. But while that's happening, you have a binding decision potentially against you. That is basically the situation. This is what we're talking about an argument for. We've spoken about amicable settlement and mediation. We've spoken about adjudication and arbitration. This is a very important table, which I think everyone's taken a photo of. And this is now the difference. 6.2 deals with it under clause 30, whereas 2005, which is the one that I think everyone here is dealing with, is under clause 30. And the problem that we have is that there is a significant jump between the 2005 edition of the JBCC and the later editions from a perspective of risk allocation and how it works. Because at the time that the 2005 edition came out, obviously there was a different need within the market. But yeah, there's a, yes. There is a case that I will, speak to you about, called the Zinguazi case. And in this specific case, again, it speaks about the idea that a party can be unhappy with a decision, but still has to enforce it. They don't have a choice. So the contractor in this case was awarded a 12 million rand decision. Department wasn't very happy with it, so they carried on as if it didn't occur. They sent it on to the next step and then refused to pay Zinguazi. And the court said that this was incorrect. And the reason that this case sits for me is that I had one of my colleagues worked on this matter specifically, an old colleague, and all of these files were in her office. And it was a massive, massive matter. And it happens on more cases than you realize. That even though an adjudicator's decision is considered binding and is a matter of contract, it's binding by contract, so not a case of, it's an automatic. You have agreed with another person that you are bound by whatever this third party says, but you decide no, that at this point, okay, it's not what I wanted, so we're not going to do it. It still costs money to go and try and enforce it, but the option is there. And you should, as a contractor, enforce it and then also apply for costs at the same time, because that would be your next solution. But basically, I've summarized, you have a notice of disagreement. You have 10 days to resolve it together. And you then issue a notice of dispute, setting out all the salient facts and appointing, declaring a dispute. And from that point onwards, you decide if you're going to go to adjudication, if that's what the contract says in the contract data, because you can't have a JBCC contract without a finished and fixed contract data. And the process follows from there. In addition to all of this, what's very important is that even if the contract's terminated, the dispute resolution procedures of a contract do not stop working. They continue being effective until prescription applies to whatever that dispute is. Does anyone in this room, when I say the word prescription, does anyone understand what I'm saying? Well, tell me what the period for prescription is. Yes, 3 years for what? Yeah. So you have 3 years in law, standard in law. You have 3 years to pursue a debt, at which point it dies. So if you have a claim, if you have a debt of 2 million rand, and it arose in 2015, and you decide only to pursue it in 2019, and you come to me with it, I am likely going to have to say to you that the money's gone. So make sure that you're aware of time bars. So the JBCC likes to work in 20, 40, 60 working days. The GCC loves 28 days. It's the golden number. The NEC works in weeks. And the FIDIC also works in but the FIDIC's weird. It's like an 84-day period. They have some other way of doing it. Make sure you know when your claim is time barred, because it specifically says you forfeit your claim, and you don't want that if you have a really good claim. We've done FIDIC and the NEC. And the last thing is just some tips, guys. So as I've said, make sure you know what amendments have been made by the employer. Make sure you know the timings of things and how they affect you. If it's from the date when something started or stopped, whether it's working days or calendar days, because that's a really important decision to make, and you'll generally find that in your interpretation clause. So the GCC works on working days, whereas the JBCC jumps between working and calendar days. So not everything is on working days. So you need to check, you need to read it. It is bolded generally in the JBCC. And then make sure you know what type of dispute resolution you're dealing with and how you can submit claims. But just as an overall construction contract tip box, I would say that the best clauses to include in your contract would be things like a risk register and early warning notices. It may be an NEC contract, but just having a risk register and a mechanism where if something pops up and you realize it's going to delay the project or could delay the project, you have a way of discussing it and fixing it, is great because it avoids disputes and claims. A clause where the principal agent, the project manager, engineer has to make a determination because it makes it, there sort of puts the responsibility on someone and gives you a starting point for any claim or dispute you might need to make. A multi-tiered approach to dispute resolution. So in a lot of contracts, you'll have the CEOs talk, project managers, CEOs, and then you only start going to adjudication. And the JBCC has amicable settlement or discussion, adjudication, arbitration. Time bar provisions and clauses, make sure you know what those are because it's unlikely that an employer is going to take them out. It would be great, but it's probably not going to happen because that's not effective for a contract. Clauses regarding the consolidation of claims between subcontractors and contractors. Because what I think, and Zama mentioned this earlier, when you are submitting a claim for payment, you want your subcontractors to have a shorter amount of time than you do because you need to push their claim up into yours. The same with a dispute. You want a situation where if something is going on with your subcontractor that affects you, that is causing a rift between you and the employer, you want to be able to bring them into the dispute. And the NEC actually does that really nicely. And the last and most important clause that needs to be put in, and that is not always present, in the modern contracts it is, but in the older versions it's not, is an interim binding effect clause. And that's what I said, that a decision is enforceable until such time as it's overturned. So even if they take it on review or whatever it is, it's still, you as the contractor still can go to court and be like, listen, I understand they're not happy, but until an arbitrator says that they're right, I need my money. And a court will, and our courts are, there's so much jurisprudence and so much case law where our courts have said, you have agreed, therefore you are contractually bound to enforce this right. Pay the money. And failure to do so is contempt, and we all know that that's a fine, going to prison, etc., etc., etc. So those are the tips that I have for you. And if you want to come and chat to myself or Zama after this, you're more than welcome to. These are our details. And that is, I think, all I have to say at this point. I ran through it very quickly because I know everyone's getting a bit tired. Are there any questions?
Yes.
I have one.
Yes, thank
It's
you.
more of what I've noticed in the industry is that most contractors don't know how to write notices to the principal agent. And as a result, a lot of their claims get dismissed by the principal agent. So I think just also a tip I would add is just for contractors to really go through the contracts and know what provisions in the contract to cite when they're writing those notices. For claiming for time and all those things, they must know what they're dealing with and to just cite specific clauses that pertain to their issues.
So I'll add to that. So a lot of the claims provisions and the dispute provisions tell you what needs to be in there. So it'll tell you that you need to, if you are issuing a dispute notice, it has to be what clause the dispute's raised under, what is the issue, what is the relief sought. If it's a claim, it will generally say, what clause are you looking at? What is the issue? Disputes and claims, their success is measured on the documents and the records that you keep. The person that has the most backup, whether it's written, whether it's recorded, that is the person who's going to be successful, but your claim can be thrown out if you don't refer to the correct clause. I think sometimes you can argue around that unless the clause is very specific. And if someone makes a mistake, a mistake of the law is not a defense in general. But yes, it is very, very important that you look at what needs to be put into a notice. And again, if you need guidance on that, that's something that we specifically offer. And it's nice to get yourself a set of templates. I don't like templates and I don't like precedents in general because I believe that things should be drafted from scratch because copy pasting doesn't work. But there are certain situations where if you have a nice starting point to work off of, it makes life a little bit easier. So again, that's the great comment. At the back, yeah.
Sorry, FIDIC, the FIDIC forms, for example, have at the back of them template notices. So an idea of what the notice needs to look like, an idea of what performance bond must look like. So you can use that as a point of reference, as a starting point.
Am I being chased away? Oh, thank you.
Thank you very much, Tamlin. Can we please give a round of applause? Thank you. I think for me, the takeouts is the use of the register and early warning notices will be a make or break when it comes to dispute resolution, right? And time bar provisions with the different clauses in the contract is of paramount importance. Colleagues online, I will take one or two questions from yourselves. If there isn't any, we'll then move on. Colleagues who have joined us on site, I will give you an opportunity to interact with our lawyers when we have lunch. Is that okay? Thank you very much. We'll now make welcome Mr. Pranveer. I always struggle to say the last name, so I keep to to the name from CIDB to take us through the certification in construction management. Over to you. I'm told I must give you 5 minutes, and you can run through this thing in 5 minutes. You do it every day. That's what Kotli said. Thank you.
Okay, thank you, Dr. Ketna. Yes, my name is Pranveer Haripsad, and I'm going to be just giving you just a heads up. It's some exciting news from the CIDB in terms of the CIDB certificate in construction management. So the CIDB certificate in construction management is actually a flagship capacity building program that has actually been designed to empower contractors to assist them in terms of delivering projects on time, according to specifications and within budget. So this is one of the things that the CIDB is doing in terms of the development of your emerging contractors. So in terms of the objective, as I mentioned, it is there to actually develop contractors, but it's also there to ensure that you have the relevant skills that are going to be required by the CIDB as well. So some of the things that will be covered in this program, basically that is targeted for contractors from grades 2 to 6, is areas of business management and planning, financial management, tendering and compliance, health, safety, environment management, and then also the introduction of technology advancements, the likes of your BIM, your AI, and what we refer to as digital twins as well. So that's the good news. So, ladies and gentlemen, it is an opportunity for contractors in grades 2 to 4 that they should take up. It's going to be fully funded by CIDB through the CIDB Build program. And in terms of the program itself, so we refer to this as a short learning program, so the SLP. And it is going to be offered to contractors that covers the areas that I have mentioned. So it's things like your project management, contract management, procurement management, building standards, digitalization, and then innovation management as well. Now, the certificate itself is going to be, it'll take you about 3 to 6 months to actually complete. And it's going to be delivered by the University of Johannesburg in collaboration with the CIDB. So the certificate, as I said, it is going to take you about 3 months to complete. Now, the way the program is designed, there's 2 compulsory modules that one has to complete, and thereafter you can select an elective. So there's 4 electives that are going to be available, and you as a contractor will then decide on which elective you actually want to take up. So just to go through some of the areas, so if you look at the compulsory modules, that's your project management, and then construction procurement management. Now, we've identified these as critical areas, so that is why we actually made them compulsory. In terms of your electives, you'll have a choice between construction contract management, construction building standards, construction digitalization, construction innovation management. So there you can then determine which is the area that you want to take up. Right. So in terms of the build program itself, that's actually delivering this program, it is there to actually support in terms of the development of contractors and even of your professionals as well. So the program itself, as I mentioned, is going to be delivered by the University of Johannesburg, and it will also get you 10 CPD points as well. And that would be through the SACPCMP. So another one of our partners that are in the room. Thank you. All right. So just in terms of how the program is going to be delivered, so it is actually going to be delivered in a hybridized format. So they are going to be in-person training sessions in all of the 9 provinces. And there will also be the online part, which we refer to as the flexible access. So there's going to be things like your videos, reading material, quizzes, peer reviews, and then you will have to do some hard work in terms of assignments as well that has to be submitted. All right. So in terms of some of the benefits that you will receive, you can actually go through them. But I think the main thing is we know that knowledge is power. We've seen that today as well. So make sure you take that opportunity to actually empower yourself and apply to be part of the program. Remember, ladies and gentlemen, seats are limited and there is a minimum requirement in terms of getting onto the program as well. We're going to be actually advertising this on our social media platform, so keep an eye out for it in the coming week and take advantage of the opportunity. Thank you.
Mr. Pranveer, you were spot on. Someone was timing you. I didn't ask them to, and you did it in 5 minutes. Can we give him a round of applause for keeping time? Thank you. Can you believe we've come to the end of our program? Okay. I just want to say one or two things before I actually hand over to management to officially close the session for us. Like I said, Mr. Pranveer, thank you for your insightful and profound presentation on the certification in construction management, affirming our role, intention, and deliberate efforts as the CIDB in developing and transforming the construction industry. For those joining us online, or even on site, and you're not sure in terms of that presentation on the module, there are 4 elective modules, meaning you can choose one, and you haven't decided which one to choose from. I will implore you to choose, you guess which one, right? Contracts management, because today we're discussing that, and I think we are all aware, even before today's discussion, the importance, or before today's masterclass, the importance of really taking contracts management as an elective. It's really important. Now, to finally and officially close off the session, let's allow Osima Tlodingwenya, who's the Corporate Services Executive at CIDB. Over to you. Thank you.
Good day. Greetings to the CIDB board, to the CEO in absentia, management and colleagues, and to the delegates. Without any waste of time, I'd like to also acknowledge our sponsors, WMN Attorneys and SACPCMP. Program Director, as we come to a close, please allow me to just reflect briefly on what was shared. Without going too lot, we looked at construction law and contract management, rights, risk and responsibilities, dispute resolution, which is critical, and the different types of contracts. We have indeed today learned so much. We have gathered information on a whole lot of things that affect us as contractors. Thank you to also on the information or certificate of construction management. Each conversation that was shared here and the questions and an engagement led to the success of this masterclass. As the CIDB would like to take a heartfelt thanks to the following, to you, Program Director. Thank you so, so much for giving your time. To Meza Mangobo and Ms. Temlin, thank you, thank you, thank you for a wealth of information. As you indicated, we would have paid so much just to get this information. Mercedes Olukheto, thank you for reaffirming that transformation is critical for the industry. Thank you for all of you for pouring your heart out, so sharing information so selflessly and having the time and the patience to take questions. This we appreciate. To Pran, my colleague, thank you so much for sharing the exciting information. The delegates are indeed happy. To the delegates who are here and the ones online, thank you so much for taking the time from your very busy schedules to attend to this information session. I'll be remiss, Program Director, if I do not thank Kotli and the team, the organizing team, for making sure that we have this successful event. Kotli and the team, we are indebted to you. So as we leave this session, I hope you've taken on the information that was shared. And also I take for granted that also you have shared connections. Please use this stage, turn them into tangible things. To reiterate what the CEO has said, as the CIDB, we remain very deeply committed to your development. We will support you through the programs, and chief of them was what was shared just today. Please continue to engage with us, ask questions, engage, look out on the website or on social media for various communication. Once again, thank you for being such an engaging audience. We wish you a blessed day further. And for those who are traveling, safe travels. Thank you.
Normally, I shouldn't come back after the vote of thanks. But I am on two reasons. One is that we haven't quite figured out how to share, to use technology to share lunch with our colleagues who have joined us virtually. That's on a lighter note. For colleagues who have joined us virtually, thank you so much for giving your time, even with the technical glitches that we had this morning. I want to thank you profusely. Okay. Thank you, Osmatlodi, for that closing remarks. I just want to pose a thought-provoking challenge to all of us, that as we reflect deeply today in terms of the time that we invested today, was it truly worth a while? And I think the yardstick that we'll use to measure today's success is when we go out there and implement these projects using the fundamentals that we've received today in terms of contract management in a better and more effective way. Then we know we have really, our time that we invested today was really worth a while. On that note, colleagues, I thank you. It's been a pleasure directing you today. Thank you.